Ron. Full screen ಬರ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ ಬನ್ನಿ list number 1 कर दीजिए हमारे 46 in the adjournment.
List number 1 adjournments page 10 46 to 49.
Serial number 49.
Hmm.
And for respondent number 4.
Yes.
I informed the council's members some medical emergency today. That's the matter. So I request
49 at the request of council for respondent number 4 relist on ಯಾವಾಗ ಬರ್ತಾರೆ
29th.
29th January.
Page 11 50 to 53.
Serial number
51.
The learned counsel for the respondent has also requested for adjournment in this case.
ಏನಕ್ಕೆ
ಅವ್ರು ಬಂದಿಲ್ಲ ಅವ್ರು
2019 GMCPC
any date in the
6 ವರ್ಷದಿಂದ ಸ್ಟೇ ಇದೆಯಾ
stay there. FDP ನಲ್ಲಿ stay there.
ಇನ್ನು
There is a RSA also pending regarding the same.
ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ
First week of February.
the council for the petitioner released on 4th February.
No,
It is made
after
clear-
5th.
Oh, sorry. 5th February. It is made clear that no further adjournment would be granted. If arguments are not advanced on that date, the petition would be liable to be dismissed for non-prosecution.
Interim order may kind of.
Interim order earlier granted is extended till next date.
Serial number 50, my lords. In
Huh?
50.2, 3 and 4, my lords. I have not received the petition copy, my lords. I have requested the advocate, my lords.
For the petitioner.
Notice order ಆಗಿದೆಯಾ
ಆಗಿದೆ ಬಟ್ ಈ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಆಗಿಲ್ಲ
ಅದಕ್ಕೆ ಕೇಳಿ
50.2 3 and 4
4 ಅಲ್ಲಿ ಆಗಿಲ್ಲ ನೋಟಿಸ್
Writ of mandamus, my lords. Short date may be given. my lords.
ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ
Please, I will serve today itself.
50.2 Ms. Sharmila M. Patil accepts notice for respondent number 2 and 3.
one state
50.3
ಅಲ್ಲ one state
1
state
ಅದೂನು ಆಗಿಲ್ವಾ
ಅಲ್ಲ ಅದು ಆಗಿಲ್ಲ
And AGA accepts notice for respondent number 1, Ms. Sharmila M. Patil accepts notice for respondent number 2 and 3.
please
50.3 same, 50.4 same.
please
Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures
Please.
by end of day 27th January, relist on 4th February.
Please.
Page 12 54 to 57. Page 13 58 to 62. Page 14 63 to 67.
Serial number 64.
At the request of counsel for respondent relist on 29th.
We need to file an objection statement in that. my lords.
Learned counsel for respondent seeks fund is granted 2 weeks time to file a statement of objection.
I'll file.
Objections, if any, to be filed on or before 7th February, relist on 12th February.
Please.
Interim order ಇದೆಯಾ
There is no intent.
and ಓಡ್ ಬಂದ್ರಲ್ಲ ಅದಕ್ಕೆ
Page 15 68 to 72. Page 16 73 to 76. Page 17 77 to 80.
77, my lord. 77, my lord.
ಎಸ್ ಮಿಸ್ ಮಾಡ್ತಾರೆ
Next week, my lord.
24 ಯಾರು ಟೋಟಲ್ ಮೂಡ್ ಯಾರು ಮಾಡಿರೋದು
I have moved, my lord.
ನೀವೇ
Yes.
ಮೂಡ್ ಮಾಡಿ ನೀವೇ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಿ 77 at the request of counsel for the petitioner relist on 31st.
Please, my lord.
71, my lord.
Yes,
Lord, may I request it, I mean, 1 week time, my lord.
at the request of counsel for the petitioner relist on 31st.
Grateful.
Page 18 81 to 83.
The list 3 ಅಲ್ಲ
List number 3 total 6 matters.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ
The other side are also undertaken to revoke my suspension, else the court was
5
serial number 5.
Service,
service matter,
let me,
28.
suspension.
Much obliged.
Your suspension there first, criminal appeal.
Service matter,
1 to 29, relist on 28th January.
much obliged. Sir.
32,
So serial number 28, sir, list 3. Serial number 28, sir. So there's an urgency in this matter. It is related to elections of cooperative society.
cooperative society. Na?
Yes, sir. It's necessary here.
28 file tarsi. 29 also cooperative society. File tarsi. In other cooperative society idea?
My lord, list 3.
Yes, list 3.
Serial number 21 and 23 kindly be called on 7/2, my lord.
21,
And 23.
have you informed the other side? 21 and 23, 1 to 20, 28th January, 21, 23, 7th February, 22, 28th January, 24 to 27, 28 January, 28 and 20, 28, 28 and come here. 28 and 29 Passover,
30 to 38.
30 to 38 ಯಾವತ್ತು ಇದೇನು 36 ಏನು ರಂಜಿತಾ ಅಲಗ್ವಾಡಿ
Number 36,
ಅದು CS ಇದೆ
VM Shield 1.
ಏನು ವೋಟಿಂಗ್ ರೈಟ್ಸ್ ಏನು ವೋಟಿಂಗ್ ರೈಟ್ಸ್ 36 Passover ಮುಗ್ದೋಗಿದ್ಯಾ ಮುಗ್ದೋಗಿದ್ರೆ ಬೇಡ ಅದೆಲ್ಲ ಯಾವತ್ತು 31st
ಉದಯವೆಲ್ಲ 31st.
ಪ್ಲೀಸ್ ಮಚ್
Serial number 2, my lords. List number 2, my lords.
List number 2 will call out on ಯಾವತ್ತಿದು ಬರುತ್ತೆ
ಒಂದು ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಒಂದು ಮೆನ್ಷನ್ ಮಾಡೋದು
ಮೊನ್ನೆ ಯಾವತ್ತು List number 2 will be ಇಲ್ಲ ಇದು orders matters. List number 2 orders matters will be called out on 30th. So by 30th ಏನೇನು process fee ಕೊಡಬೇಕು ಏನೇನು ಮಾಡಬೇಕು ಎಲ್ಲ ಮಾಡಬೇಡಿ.
My lords, interim orders may kindly be extended, my lords. Serial number 2, list number, serial number 12.
Called out. The B group 27 to 40 will come on ಯಾವತ್ತು 4th and 5th 10 matters will get distributed.
My lords, serial number 2 and serial number 12, my lords. Interim order may kindly be extended, my lords.
It will interim orders extended.
List to serial number 3, interim order.
IA orders ಒಂದು ನಿಮಿಷ ಏನಪ್ಪ
List number 2, serial number 20. Naveen Chatrat,
20 during the pendency of the above matter respond number 2 has expired, hence IA 1 of 24 has been filed. Issue a notice on IA 1 of 24 returnable by 26th March. 21 during the pendency of the above matter respond number 2,
Patil,
respond number 8 and respond number 9 have expired, hence IA 1 to 6 of 2021 and 1 to 3 of 2024 have been filed. Issue notice on the said applications returnable by 26th March. ಎರಡೇನಾ? ಟು ಎ ಟು ಸಿ ಆರ್ ತೆರಗುಂಟಿ ಇದ್ದಾರೆ ಬರ್ಲಿ ಕರ್ಯ ಎರಡೇನಾ ನೋಟಿಸ್
yes.
serial number 31 in the first list.
31
Also 31. Senior son's JE exam is scheduled today. My lord. He is senior son's JE exam is scheduled. My lord. He has gone to Bangalore. My lord.
he is going to write the exam.
I have requested Dinesh Kulkarni also. My lord.
31 at the request of counsel for the petitioner relist on 5th.
Interim order.
ಅಷ್ಟವರೆಗೂ ಎಕ್ಸಾಮ್ ಬರೀತಾರೆ 5th interim order earlier granted is extended till next day.
Your lordship,
Serial number 23 in list 2, Your Lordship. The parties have settled the dispute before the Lok Adalat, Your Lordship.
List 2, serial number 23. Padi. Memo dated 24, petitioner is before this court seeking for the following reason. Memo dated 24/1/25 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the said memo and submission of counsel for the petitioner, petitioner is dismissed as settled before the Lok Adalat.
Obliged.
List 1.
Serial number 17, my lord. Serial number 17, my lord.
70.
Yes. We will pay PF.
List number.
List 2.
Yenamma, you are for?
Appellant, my lord.
Appellant alla petitioner.
Yes, my lord.
Court all moved.
List 2. List 2, my lord.
List
we will,
2.
Yes, my lord. Please.
Compliance model.
So,
17.
7. My lord, interior matter action. Please.
List 1, orders matter. SS Baba Khan.
In this, I am for petition number 2, my lord. Already the notice has been issued to the 3A, respond number 3A, served and Chaklabi is appearing on the
Obrena 3A matra na.
3A.
Senior has filed Wakala, independently. I will undertake to file Wakala with respect of 3A.
ಆಯ್ತು
Name make and.
ಅಲೋ ಮಾಡ್ತೀವಿ.
Please allow.
During pendency of the above matter, respond number 3 expired on?
Date is.
Then 2012 application pending ಇದೆಯಾ Mr. Suresh? ಏನಪ್ಪ ಇದು? ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
14/9/2011. Died on 14/9/2011.
14/9/2011.
2011. Yes, ma'am.
Hence,
In IA number 1.
1, 2, and 3 of 2012 have been filed. Notice having been issued to the legal representative of deceased, respond number 3. Same has been served and is represented by counsel. Accepting the reasons stated in support of IA 1.
Memorandum of facts. Filed by the.
ಇಲ್ಲಿ ಡಿಲೇ ಎಷ್ಟಿದೆ?
Delay days were not mentioned in the IA, my lord.
ಮತ್ತೆ ಹೆಂಗ್ ಕಂಡೋನ್ ಹೆಂಗ್ ಮಾಡೋದು Mr. Suresh?
That is one of the objections.
174 days.
Yes.
He is condoned. Accepting the reasons stated in support of IA 2 of 2012, the abatement in respect of respond number 3 is set aside by allowing IA 3 of 2012. The person named therein is brought on record as respond number 3, capital A. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Shri so-and-so submit that you would be filing wakalatnama for respond number 3A. Registry direct print his name as such and delete the name of Ms. Sumangla Chaklabi as that appearing for respond number 3A. Pleadings complete?
Complete.
Records beka?
Records is not necessary, my lord. Records
Counsel for the petitioner submit that records are not necessary. Similarly, the submission made by counsel for respond number 3A.
It may kindly take on.
Both the counsels, all the counsels are directed to get ready to address arguments. Relist on
31st.
31st.
2. SP Dodgowda.
Yes. In this case, during the examination, my senior has filed memo for retirement. I will continue in the matter, lords. Her name may kindly be deleted. My senior has. Yes, I will continue. I will continue. And the name of Sumangla Chaklabi can discontinue.
See the interim order that they have.
We are ready to argue.
Lords,
Yes, my lord. Yes.
You are ready.
I need 4 days time, lords. 5 and 31st.
Memo for retirement has been filed by Ms. Sumangla A. Chaklabi. They said memo of retirement is accepted. She is permitted to retire from the matter. She is discharged. Registry to continue the name of Sri S.B. Dodgowda as that appearing for the petitioner. He seeks for and is granted 4 days time to get ready and address his arguments.
Have it on 31st.
4 days, 31st elagat. Released on 31st. It's made clear that no further adjournment would be granted if arguments are not advanced. Petitioner would be liable to be dismissed for non-prosecution. Interim order earlier granted is extended till next date.
Much obliged.
3, Sangram Kulkarni.
Please, my lords, I appear in this matter with Mr. Kulkarni. Lords, this matter relates to abatement of a suit.
Ready?
I have some.
Along with the affidavit filed by dispensation. Dispense ಮಾಡಬಹುದಾ?
Yes, it is already
Annexure
allowed. my
K,
lord.
A and B ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
I1 of 2020 and 2 of 2020 have already been allowed by order dated 21/1/2025. Hence, no further orders are required to be passed in relation thereto. The affidavit filed along with documents is taken on record. At the request of counsel for respondent, relist on?
Oh, I see. I'm so sorry. I didn't realize he was taking time. If your lordship would keep it on 7th, my lords.
7th February.
My lords, I take it my learned friend will go on that. Definitely.
Interim order earlier granted is extended till next day.
Grateful, your lordship. Grateful.
4, NL Batkurki.
Commissioner report. Commissioner report ಬಂದಿಲ್ವಾ? Copy ಕೊಟ್ಟಿದ್ದೀರಾ? Have you furnished copies to them? ನಮ್ಗೆ ಒಂದೇ ಕಾಪಿ, ಅವರಿಬ್ಬರಿಗೆ ಬೇಡವಾ? ಕಾಪಿ ಕೊಡಿ. ಕಮಿಷನರ್ ಫೀ ಫಿಕ್ಸ್ ಆಗಿ ಪೇಮೆಂಟ್ ಆಗಿದೆಯಾ? ಫೋಟೋ ಕಾಪಿಂಗ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಲ್ಲ ಕವರ್ ಆಗಿದೆಯಾ? The commissioner who is present before this court has filed his report. He is directed to furnish a copy thereof to the counsel for the petitioner and respond number 1 to 3. The ಯಾವ್ದು ಕೊಡ್ತೀರಾ? ಕಾಪೀಸ್ ಯಾವ ಕೊಡ್ತೀರಾ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಕಾಪಿ? ಯಾವ ಕೊಡ್ತೀರಾ? The commissioner submit that said copies will be furnished in 2 days' time. Both the counsel seek for a week's time to go through the same and make their submission.
My entire copy is not with him.
ಅದಕ್ಕೆ ಕೇಳಿದ್ದು. ಹೊಡೆದಾಕಿ ಅದು. The commissioner who is present before this court submits that he would be filing the report with the registry during the course of the day after serving copies thereof on the counsel for the petitioner and respond number 1 to 3. The counsel seek for and are granted a week's time to go through the same and make their submission. Relist on 5th February. ನೀವು ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಳ್ಳಿ. ಕಮಿಷನರ್ ನೀವು ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಳ್ಬೇಕು ಯಾವಾಗ್ಲೂ, ಫುಲ್ ಕಾಪಿ, ಬರೀ ರಿಪೋರ್ಟ್ ಅಲ್ಲ. ನಾಳೆ ಏನಾದ್ರು ಕೇಳಬೇಕು ಅಂದ್ರೆ ಅದ್ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ನೀವು.
That last time it was returned, there is no provision for submitting before registry that he says.
ಏನು?
Commissioner report.
The registry shall accept the report once filed.
5, Saint Bankar.
Sale number 20.
Office objection is with regard to the legible copy, my lord. I invite our lordship kind attention to page number 19.
G.
So far as annexure B is concerned, I have produced typed copy of annexure B, my lord, at page number 20, my lord.
Annexure E is page.
Annexure B, my lord.
E
Annexure
ಅಲ್ಲ, E, F, G.
G. Yes, D is.
D ಮೇಲೆ ಏನು ಇದಿಲ್ಲ.
Yes, my lord.
Legible type copy of annexure E. E for elephant, F for France, G for Goa.
Yes, my lord. Please, my lord. Annexure G is concerned order passed by the Tahsildar, which is legible and visible, my lord.
E.
Annexure G, my lord.
E first ಹೇಳಿ. E ಎಲ್ಲಿದೆ? Page number, encumbrance certificate.
32, my lord.
Accepting the submission of the counsel for the petitioner of his objection in respect of annexure E, he is overruled since the same is a certified copy of the encumbrance certificate. accepting submission of the counsel for the petitioner of his objection as regards annexure F is overruled since the same is a sketch.
Yes.
G.
G is order passed by the Tahsildar, my lord.
Huh. Elli type copy ellide?
That is also legible and visible, my lord.
La type copy ant ಹೇಳಿದ್ರಲ್ಲ.
Typed copy B, my lord. B I have produced typed
Refusal
copy.
of annexure G indicates that the same is legible, hence office objection in relation thereto is also overruled.
Yes.
Yes.
And the government advocate may be directed to take notice to respond number 1 to 4, my lord.
ಹೋಗಿದೆ notice.
And 5 and 6 I will pay process fee, my lord.
Government has taken notice already.
Yes.
Notice to 5 to 7 is deferred for the present.
Yes, my lord.
ಏನಿದೆ ಹೇಳಿ? Deferred andre,
Please, ma'am.
deferred andre you have to make out a case.
Yes, my lord.
What is it that you are seeking for?
Short date may be given, my lord. I will come prepared on that. Because
At
it
the request
pertains
of
to
counsel for the petitioner, relist on 31st.
31st.
6 Vidyavati Kotru Shettar.
I appear for petitioner, my lord.
Yes.
This is the matter wherein, my lord, on 31st/1/2024, your lordship has allowed the writ petition with a direction to the government to comply the order within 4 weeks.
ಅಲ್ಲ, ಇದು ಬೇರೆ ಇದೇನು? Okay. ಅಲ್ಲ, implement the general direction issued in 7725. ಅದು
Please.
ಬೇರೆ. That we are taking care of in that matter.
Please, my lord, in this matter, my lord, a specific direction is, my lord,
Within
Roman
4 weeks.
Roman 2. Yes, that is not complied till date.
Contempt ಹಾಕಿ.
Yes, my lord, I have filed a contempt.
Huh.
The contempt says, in the contempt, my lord, this is the order passed in a contempt. They says that 2 lakhs is due, it is complied. But whatever the direction is,
Then item 3 says you are at liberty to file a suit for resolution of the dispute by way of arbitration or by way of arbitration.
your lordship kindly see the operative portion of the order passed by your lordship in
Yes.
para number 2. Para number 2, the petitioner claimed to be a class 1 contractor who has carried out installation of wave-in motion or automatic traffic counter on the basis of tender issued by the respondents. The contract, though executed on 2/1/2010, and the demands raised for payment, the respondents have been delaying the matter and not making payment of due amounts. Several letters issued by the respondents over a period of time has not evoked any particular response from the respondents. Even an arbitrator having been appointed, the arbitrator withdrew his consent to act as an arbitrator. A second arbitrator being appointed, he also withdrew the consent due to non-cooperation of the respondents. It is on that basis it is contended that the respondents are seeking to evade payments and not to cooperating the resolution of dispute between the parties. As observed by the Honorable Apex Court in the case of Mrs. Ravi Constructions, and also your lordship judgment in WP number 7725 of 2023. It is required of the state and its authorities to determine them and make payments
Oh,
of
they have determined as 2 lakhs. Wrongly determined in
No,
prakara.
no. It is in the petition itself, my lord, it is narrated 2 lakhs is the original bill due. There is a delay and they agreed in the earlier and arbitrator is appointed to settle the matter. It is not arbitrator is withdrawn because of non-cooperation of the government. Even second time also arbitrator is appointed by the government. It is also not settled, my lord. My due is 49 lakhs. Now they paid only 2 lakhs. Whatever the bill, original
This
bill.
writ petition cannot be for recovery, madam. You will have to file a suit.
No, my lord, your lordship kindly see the WP number 775 of 2023.
See,
And
operative.
further I may be permitted to read 4 lines.
ಏನಿಲ್ಲ ಆಯ್ತು ಓದ್ಬಿಡಿ 4 ಲೈನ್.
Please, my lord.
ಇನ್ನೇನು?
And its authorities to determine and make payment of the due amounts if there is any genuine dispute as regards liability to at least make known to the said dispute so as to enable the party like a contractor to seek for adjudication of its claim. In the present matter, even the adjudication through an arbitrator has been sought to be frustrated by the respondents by non-cooperation of the arbitrators themselves withdrawing the consent. This speaks very poorly of the state, and that an arbitrator had to withdraw the consent on account of non-cooperation of by the state. Again, if you go for the arbitrator,
You
same
go
result.
for a suit. They can't, now they cannot say no to a suit.
Your Lordship, kindly see the direction issued in the Supreme Court, my Lord, as I have narrated at the time of the writ petition. Your Lordship, kindly see, this is for recovery also, reconstruction, and also Your Lordship judgment.
Madam, we are functus officio insofar as the merits of the matter is concerned. We have already disposed the matter. If contempt you have filed and contempt is disposed, you can't re-agitate the matter in the writ petition where we have disposed it of.
No, the contempt, that direction issued by this honorable court is not complied.
Can
Though
only be
there
agitated
is
in
a
contempt,
direction.
not before us. ನಿಮ್ ಕಂಟೆಂಪ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
The compliance report is not filed till date.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ?
No, not filed.
ಮತ್ತೆ ಅಲ್ಲಿ ಅಜಿಟೇಟ್ ಮಾಡಿ, ನಾಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
The thing is, my lord, your lordship, kindly see the contempt order, my lord, they are
ಇವಾಗ ಕಂಟೆಂಪ್ಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ, ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ?
ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅದು
ಮತ್ತೆ
ಕ್ಲೋಸ್
ಇನ್ನೇನ್
ಆಗಿದೆ. ಬರೀ
ಮಾಡುತ್ತೆ?
2 lakhs ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. 2 lakhs ಅಷ್ಟೇ. 49 is claim. My petition is regard, my prayer is different.
Please understand, we are functus officio. Once we have passed this order, you have filed a contempt, the contempt is closed. A contempt ಅಲ್ಲಿ agitate ಮಾಡ್ಬೇಕು, ಇವೆಲ್ಲ ನೀವು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅಂತ. ಇಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ಲ.
My humble submission is, my lord, there is a direction, specific direction.
That is done. You have filed contempt, that's also closed.
No, that direction is not considered in the contempt. That direction is not considered.
Then you
in
file
the
an appeal against the contempt order. You can't agitate it before us. That will not be proper. Division bench has passed an order, we are bound by that.
But your lordship, kindly see the direction of Roman number 2.
Determine and pay, we have not said 49 lakhs.
Third prayer is also clear.
If you are not satisfied, file a suit. The submission, there is no compliance report which is required to be filed in the present matter. Since the compliance is required to be filed in WP 7725 of 2023. The submission of learned counsel for the petitioner is that the submission of Ms. Vidyavati Kattu Shettar, learned counsel for the petitioner, is that the determination made by a respondent is not proper. The dues to the petitioner are to an extent of 49 lakhs, but the determination is made of only 2 lakhs. On inquiry as to whether contempt proceedings had been filed, she submitted that contempt proceedings had indeed been filed, and the compliance submitted by the state has been accepted by the contempt court.
Yes.
If that be so, this court cannot look into the aspect of the determination. Liberty has already been reserved to the petitioner to file a suit or seek for resolution of the dispute by way of arbitration. At this stage, learned counsel for the petitioner submits that the two arbitrators earlier appointed had to withdraw their consent on account of the non-cooperation of the state. Since the state has not cooperated in the arbitral proceedings, the state cannot have any defense to the petitioner initiating filing a suit for recovery, contending that there is an arbitration clause. The state has forfeited its right to arbitration by non-cooperating with the arbitrator. Needless to say, the petitioner would also be entitled to the benefit of section 14 of the Limitation Act for the time spent in the arbitration as also in the above writ petition. With the above observation.
And one more compliance report in Roman number 5. Though the above matter is disposed to report compliance.
So Roman 4 gather.
Roman 4 gala, Roman 192, my lord.
Contempt ಆಯ್ತು.
But it is not.
Please don't do this.
Though there is a direction, they don't have any.
Mandamus has a very limited role.
But they don't have any respect to the direction issued by these courts, my lord.
Illala.
7, MCU carry.
Appearing for the proxy counsel for the petitioner.
Notice issued to respond number 6 has been returned with the endorsement refused.
Refuse, my lord, maybe.
Hence, service of notice in respect of respond number 6 is held sufficient. Registry is direct print the name of respond number 6 with the endorsement refused.
My lord, remaining, my lord, pray for, my lord, 2 weeks time may be granted to take steps in respect of, my lord,
The
deceased
memo along with
R5 and
documents
14.
filed by respond number 15 and 16 is taken on record. Counsel for the petitioner seeks for and is granted 2 weeks time to make payment of necessary process fee in respect of the unserved respondents as also file applications to bring the legal representative of deceased respond number 5 and 14 on record. Relist on 18th February. If needful is not done by then, the petition would be liable to be dismissed for non-prosecution.
Interim order, my lord,
Interim
till,
order earlier granted is extended till next date.
please.
8, Manjunath G. Patil.
Counsel for the petitioner seeks for and is granted a week's time to make payment of process fees. If needful is done by 31st January, registry is directed to issue notice to the unserved respondents returnable by 27th March. If needful is not done by 31st January, relist on 5th for dismissal.
9, PG Mogali.
Third respondent has produced certain documents brought through the memo. They may continue to be considered along with main matter may be posted for B group.
My lord, since taken on record, really. Ready, ilva?
Next. 2 weeks.
My lords, if the lords, it is some inconvenience to my brother, I would not press on the matter. But on the last occasion, it was submitted. I had not supplied a copy, which I have given.
Now subsequently,
Because the issue is,
document is supplied, my lord. Subsequently
the
supplied.
issue is, my lord,
Issue will consider same. Learned counsel for the petitioner confirms receipt of the documents, memo and documents filed by respond number 3. The said memo and documents are taken on record.
Great.
Counsel for the petitioner seeks for and is granted a week's time to go through the same and make his submission. Relist on 31st
Please.
January.
please.
In B group.
Yavrilla barala. Office will see that.
Amit Deshpande, Raghavendra Purohit.
Kindly pass over, my lord. During course of the day, I will comply all the observation. During course of the day, my lord, I will comply the observation.
Counsel for the petitioner seeks for and is granted 2 days time to comply with the office objection. If office objections are not complied with by 27th January, the petition would be liable to be dismissed for non-prosecution.
No, my lord, one
Relist on
submission, my lord.
31st January.
It may pass over, my lord. During course of the day, my lord, I will comply, my lord.
ಇಷ್ಟೊಂದಿದಾವೆ
There are also some minor objections.
ಒಂದು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
Please,
ಮಾರ್ಚ್ಗೆ ಹಾಕ್ತೀವಿ.
no, no, my lord.
ಪಾಸ್ ಓವರ್.
Please.
Pass. Good. 11, Sharad Patil.
Appearing for the respondent. Today they have served the copy.
R7 ga?
Yes, ma'am.
What about the other respondents?
I will undertake to file wakalat.
1 to 6.
Yes, ma'am.
ಅಷ್ಟೇನಾ ಇರೋದು?
Milords, request on Monday, Milords.
ಕೊಡಿ ಪೆಟಿಷನ್ ಕೊಡಿ.
Milords, other office objection, Milords, in respect of
ಎಷ್ಟು ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದಾರಪ್ಪ?
respondent, Milords,
15 ಇದ್ದಾರೆ.
Yes, ma'am.
the Amlet text.
Respondent 7 is a plaintiff.
Milords, 1 to 10, Milords, they are the plaintiff in
I
this.
undertake to file.
N. Kulkarni, who has filed caveat for respond number 7, accepts notice for respond number 1 to 6 and 8 to 10.
Yes, ma'am.
Notice to respond number 11 to 15 is dispensed with since they are co-defendants at the request of the counsel for the petitioner. Counsel for the petitioner seeks for 2 days time to comply with the office objection. Relist on 29th January.
Please.
Milords, obliged.
12, Girish Advard.
Kindly a week's time, my lords. A week's time, my lords.
Counsel for the petitioner seeks for and is granted a week's time to comply with the office objection. If the
Any-
same is not complied with by 31st January, will be liable to be dismissed for non-prosecution. Relist on 5th. ನೀವೇ ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು.
Any date, my lords.
5th.
Obliged.
13, BB Somapur.
ಏನಕ್ಕೆ ಕಂಪ್ಲೈನ್ಸ್ ಇಟ್ಕೊಂಡು ಮೂವ್ ಮಾಡ್ತೀರಾ? Counsel for the petitioner seeks for and is granted a week's time to comply with office objection. If not complied with by 31st relist on 5th for dismissal.
14, Sharat Patil.
Lords, needful is 10 minutes. I've complied with the office objection, Lords.
Heli.
Lords, proposed dependent Lords file an application Lords under 1 Rule 10(2) Lords to implead him in the suit. Lords, suit is Lords. Lords, suit is for permanent injunction Lords. Lords.
And you are?
Lords, I am the proposed plaintiff number 2.
Plaintiff number 2.
Plaintiff. Lords, I wanted to be impleaded in the suit, my Lords. By way of the gift deed executed by the plaintiff number 1. By defendant number 1, my Lords.
By plaintiff number 1 and
plaintiff number 1. Plaintiff number 1. My Lords, the trial court says, my Lords, just take your Lordship's movement, my Lords, at page number 60, my Lords. It says, my Lords, got it, para 8, my Lords. It says, my Lords, on perusal of the entire records, the plaintiff filed only a relief of permanent injunction. In a bare injunction, plaintiff has to prove his possession over the suit property as on the date of the suit, and also interference of the defendant in his possession and enjoyment. The present case, it is contended by the proposed plaintiff that his father executed a registered gift deed in his favor, and he has become the owner of the suit property. Therefore, he has to be impleading as a party.
You can file a separate suit.
No, my Lords. Now, my Lords, in the same suit, if I'm impleaded, nothing harm will be caused, my Lords. If injunction is not.
You were not there on the date that interference happened.
No, my Lords. Now,
what will have to be considered is the date of interference.
Interference is concerned. Now, my Lords, if the suit also is dismissed, if it is decreed, my Lords, it is dismissed, then it will not bind on the proposed plaintiff number 2. Again, a fresh, again, parallel proceedings has to be initiated.
Either withdraw, but plaintiff doesn't have any interest.
Now,
either dismiss agatte.
I'll
Please understand.
Yes, yes.
This suit is bound to get dismissed.
Lords, that will not it is.
It's bound to get dismissed. It will only be a waste of time for the court to go through the process.
No, my Lords, only one contention is concerned, my Lords. A registered gift deed has been executed by the father of the plaintiff. Now, my Lords, in the case, my Lords, let me implead it, my Lords. I just since
the cause of action pleaded in the plaint does not inure to your benefit.
Yes, yes,
when you had no right.
So take out notice, my Lords.
We'll reserve liberty for you to file a separate suit. Petitioner is before this
and
court.
also, my Lords, if any judgment, sorry, my Lords, I'm making one submission, my Lords. If any suit is dismissed or something, my Lords, that will not affect my.
Your successor in interest, it will bind you. ನಿಮ್ ತಂದೆಗೆ ವಿಡ್ರಾ ಮಾಡಕ್ಕೆ ಹೇಳಿ ನೀವು ಫೈಲ್ ಮಾಡಿ.
ಲಿಬರ್ಟಿ ಸದ್ಯಕ್ಕೆ ಅದೊಂದು
ಅಷ್ಟೇ. Petitioner is before this court seeking for the following reliefs. Notice to respondents is dispensed with in view of the proposed order to be passed. A suit for permanent injunction was filed by respondent number 1 against respondent number 2 and 3. During the pendency of the said suit, the plaintiff executed a gift deed in favor of the petitioner herein, who is his son. In that view of the matter, the petitioner filed an application under Rule 10 of Order 1 of the Code of Civil Procedure to be impleaded in the said suit as a party plaintiff. Number 2, the said application came to be rejected, while the impugned order dated 30th July 2024. It is challenging the same. The petitioner is before this court. The submission of Sri Sharan M. Patil and counsel for the petitioner is that a gift deed having been executed in favor of the petitioner has an interest in the property and as such can continue with the suit. I am unable to agree to the submission made by the counsel for the petitioner, inasmuch as the suit is only one for permanent injunction, where the cause of action pleaded by the original plaintiff is that the defendants sought to interfere with the possession of the original plaintiff on 3/10/2022. As on that date, there was no gift deed executed in favor of the petitioner herein, nor was any interference made with the possession of the plaintiff. Thus, the cause of action which has been pleaded in OS number 1176 of 2022 will not inure to the benefit of the petitioner, and as such the petitioner cannot be impleaded as a party plaintiff in the said suit. If at all there is any interference in the possession of the plaintiff being in possession, if at all the petitioner is in possession and there is any interference with the possession of the petitioner, the petitioner could always file a fresh suit on the fresh cause of action. Reserving such liberty, the petition stands disposed.
Dismissed, but disposed of anta.
ಅದೇ disposed ಅಂತ ಹೇಳಿ. Liberty ಕೊಟ್ಟಾಗ disposed. Liberty ಇಲ್ಲ ಅಂದ್ರೆ dismissed.
Great. 15, Jagdish Patil.
Petitioner. Lands of the petitioners were notified in the year 2011. Subsequently, we have challenged the said notification. Your Honor, that there was a specific order by this honorable court to file an 18 reference and as there was a difference of your Honor, that the details of the service of notice under section 37(2), endorsement has been issued. That endorsement I have challenged your Honor, annexure G. In page 91, your worship. Notice, sorry.
There is no interim order.
No interim order.
Learned AG accepts
May I make
notice.
one more submission arising of a same notification of this honorable.
ಆಗೋಗಿದ್ಯಾ?
ಆಗಿದೆ ಅದು. Check ಮಾಡಿ ಹೇಳಿದ್ರೆ.
I'll go through and make submission.
Pass.
Hi, please.
Sixteen, Turaj Balloli.
Your Lordship, kindly be listed on Monday, to comply the office objections.
Counsel for the petition seeks for and is granted a week's time to comply with. If not complied by 31st, relist on 5th for dismissal.
17, Umesh Hakkarki.
For the petitioner, further office objection raised, my lord, with regard to serial number 29.
By 31st, relist on 5th.
Writ of mandamus with regard to office objection number 29. It's legible, my lord, to the extent, my lord. Annexure J. It's a notice, my lord, page number 28.
In mandamus, what are you seeking for?
To act in terms of notice annexure K, my lord.
यार Yellapur Patan Panchayat. Shri SV Yaji is directed to accept notice for respond number 1. Municipalities Act, section 87, na?
Please.
ಕೊಟ್ಟಿದ್ದಾರಾ notice?
At annexure K, my lord, series of notice has been given, my lord, and since from 2023, several notice has been issued, but no action has been taken.
Issue emergent notice to respond number 2, returnable by 18th February. Respond number 1 is directed to cause inspection of the property of the respond number 2, bearing site number 23-6-75. Bracket old survey number 20/16 and submit a report as to the nature of construction, as to whether there is any plan sanction obtained. If so, whether the construction is in accordance with the plan sanction, nature of construction, violation, if any, as regards setbacks, total constructions, and the ground coverage. The inspection to be carried out commencing from 10:30 AM on 31st January after issuance of a notice to respond number 2. Report to be filed by 6th February, relist on 11th February. In the event of during the inspection, it being seen that respond number 2 is carrying out any illegal construction or in violation of the plan sanction, respond number 1 shall ensure that there is no further construction which shall be put up by respond number 2. Relist on 18th.
Office objection.
In the meanwhile, office objection at CL number 29 stands overruled.
28 small paragraphs number correction. I will carry out.
Counsel for the petitioner is permitted to comply with office objection CL number 28.
But Dinesh Kulkarni.
And copies to be furnished by end of day 25th failing which the interim order will stand automatically vacated.
Dinesh Kulkarni appears. Yellapur.
Dinesh Kulkarni.
18, Srinath Pachapure.
Notice is awaited, my lord.
Yaru respondent.
Commissioner, we also served the city corporation, Ballari.
Yaar standing counsel.
SS Chalwadi, my lord. We have served SS Chalwadi.
Rest Rakanan. Shri so-and-so is directed to accept notice for respondent.
Sole respondent.
Registry is directed to print his name as such
Please.
in the cause list. Counsel for the petitioner submits that he has already served copy of the petition along with all the documents on relist on 31st.
Interim order may kindly be extended.
Idya?
Please, my lord.
Interim order earlier granted is extended.
That's what dispensation application we disposed.
Accepting the reasons stated in support of IA 1 of 25, production of certified copy of Annex A is dispensed.
19,
Same, my lord.
Same order.
Interim order may be.
Connected matters, though.
Please, my lord, connected.
18 and 19 connect.
Please.
20, SS Niranjan.
Please 2 days time, my lordship.
Counsel for the petitioner seeks for and is granted 2 days time to comply with office objection relist on 29th.
Yeah, please.
21, Avinash Mali Patil.
Only one office objection, my lords. Two office objections are already complied, my lords. Court fee has been paid, my lords. And my lords, a copy also served, my lords.
Counsel for the petitioner submit that court fee has been paid. Registered to verify. He submit that copy, the learned AGA confirms receipt of the petition. Hence office objection at serial number 43(3) stands complied.
I'm not.
Then surname, you know.
Surname, my lords, Patil and my lords, I will, during the course of the day, my lords.
And what is this?
Yes. Writ of mandamus, my lords.
What is the representation?
Annex D, my lords. Annex D and E, my lords. Page number 17, my lords.
You have to challenge this. You want to remove the name of Basama.
Yes, my lords.
Mandamus ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ ಅದಕ್ಕೆ?
Registered will, my lords. Annex A is the registered
ಅವ್ರ
will.
ಹೆಸರಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು? Mandamus ಕೇಳಕ್ಕಾಗಲ್ಲ ಅದಕ್ಕೆ.
Mandamus cannot be issued. Mandamus cannot be issued.
Mandamus cannot be given to remove somebody else's name. We'll reserve liberty to.
Please.
Petitioner is before this court seeking, learned AGA accepts notice for respondent. Petitioner is before this court seeking for the following relief. The representation dated 4/7/2014 at Annexure D and the representation dated 6/12/2024 at Annexure E submitted by the petitioner is to delete the name of Srimati Basamma, wife of Adappa, from the record of rights and make the entry of the name of the petitioner after carrying out 4D and Durasti proceedings. Since the name of Srimati Basamma is already on the record, such a mandamus cannot be issued. The petitioner could always challenge the entry of the name of Srimati Basamma by instituting appropriate proceedings. Reserving such liberty, the petition stands disposed.
Please.
22, Manjunath Torgal.
Lords, 2 weeks time for a compliant officer. 1 week time.
Counsel for the petitioner seeks for and is granted a week's time to comply by 31st, if not dismissal on 5th.
23, V.S. Kalsurma.
Please. The office objections insofar as 43.1 is, my lord, petitioner to be stated satisfactory reasons for filing joint petition. Lord, that is the first objection which has been.
This will determine what is satisfactory reason.
Since the relief claimed by all the petitioners, they are the street vendors. They have submitted a representation seeking permission, my lord.
The submission of learned counsel for the petitioner is that all the petitioners are street vendors.
Yes.
And are jointly seeking for the relief sought for. Hence, office objection at serial number 43(1) is overruled.
Second is court fee 400 rupees
Counsel
additional.
for the petitioner submit that the court fee has been paid.
Yes, 100 rupees I have paid, but they are seeking 500 rupees. 500 rupees. Additional they are seeking.
400 ಅಲ್ಲ 4 ಜನ ಇದ್ದೀರಾ?
5 ಮಂದಿ ಇದ್ದಾರೆ, 100 ತುಂಬಿದ ಬಂದಿದೆ ನಾನು.
ಒಬ್ಬೊಬ್ಬರು 100 ರೂಪಾಯಿ ಕೊಡಬೇಕು ಟಿಕೆಟ್.
ಆಯ್ತು, ಪ್ಲೀಸ್.
ಒಂದು ಟಿಕೆಟ್ ಅಲ್ಲಿ ಎಲ್ಲರೂ ಬರಕ್ಕಾಗಲ್ಲ.
Please, I will pay.
Counsel for the petitioner seeks for.
Today itself I will pay.
Submit that court fee has been paid.
Yes.
Additional deficit court fee has been paid.
In 43 is, my lord, a deponent identification, advocate's name has to be signed in the affidavit. That has been taken care.
Counsel for the, submit that the office objection serial number 43-3 is complied with.
Not 4 is annexure D, E, G to be described in the writ petition. That are part of the writ petitions, and I have narrated for what reason that representations have been.
Submission of counsel for the petition office objection serial number 43-4
Please.
is overruled.
Yes. The present writ petition is seeking a writ of mandamus to consider the representation, permitting them to put up the stalls at the Murdeshwar beach. And they have submitted the representation to the Chief Executive Officer, Jilla Panchayat. Since, my lord, they have permitted others, we have produced the photographs.
Yeah, respondent.
SV Aji appears for R1.
Shri SV Aji is directed to accept notice for respond number 1.
Please.
2.
Video illa yaru illa. So notice can be emergent notice, my lord. Otherwise, I will take hand summons to them.
Video gyakilla.
Illa video yaru illa.
List ಮಾಡಿಸಿದೀವಿ.
ಅಲ್ಲ ಮಾಡಿದ್ದೇವೆ, ಅದರಲ್ಲಿ ಬರೀ only in so far as ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ and ತಾಲೂಕು ಪಂಚಾಯತ್ ಅಷ್ಟೇ. ಲಿಸ್ಟ್ ಇದೆ. ಇಲ್ಲ ವಿಡಿಯೋ ಇದೆ, ಬಟ್ in so far as this Murdeshwar is concerned is not.
PDO ilva, Murdeshwar PDO ilva.
Murdeshwar PDO illa adaralli.
Counsel for the petitioner submits that in the list which has been uploaded by the Rural Development and Panchayat Raj Department, there is no mention of the standing counsel for respond number 2. Hence, the Principal Secretary, Rural Development and Panchayat Raj is directed to look into the same and update the list of all the PDOs, if not so updated, like that of respond number 2.
Please.
Issue emergent notice to respond number 2, returnable by 6th February. Counsel for the petitioner is permitted to take out and summons on respond number 2.
Please.
Suraj Mudhol.
Respondent.
Allowed. Ready?
I'm ready.
Please. The impugned, the petitioner has challenged under the impugned resolution void annexure F, page 57, wherein the resolution passed on 26/7/2019 void annexure C has been cancelled without notice to the petitioner. Not the.
What is the earlier resolution?
Not the page annexure C.
Number, you know?
Annexure C.
Item number running page 69, my lord.
69.
12B anta ide, my lord.
Item number. 12B, my lord. Page 69, my lord.
12B.
My lord's got
page 68.
Page 69, my lord. Item number 12B. Resolution.
ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನ
Yes,
ಸಮಿತಿ ಇವರಿಗೆ ನಿವೇಶನ ಕೊಡುವ ಕುರಿತು. That is 12B at page 68.
Sorry.
ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಪೇಜ್ ಎಕ್ಸ್ಟ್ರಾ ಇದೆ ಹಿಂಗೆ.
ಅವ್ರು
ನಮ್ಮ ಹತ್ರ
ಕೊಟ್ಟಿದ್ದು
ಒಂದು ಪೇಜ್ ಕಮ್ಮಿ ಇದೆ.
ಅವರೇ ಕೊಟ್ಟಿದ್ದು ನನಗೆ.
ನಿಮ್ಮ ಇಬ್ಬರ ಹತ್ರ ಒಂದು ಪೇಜ್ ಎಕ್ಸ್ಟ್ರಾ ಇದೆ. What are you suppressing from this?
No.
ಒಂದು ಪೇಜ್ ಇಲ್ಲ.
ಅವ್ರದ್ದು 69 ಇದೆ.
ಒಂದು ಪೇಜ್ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ.
Sorry.
ಹೇಳಿ.
Not by virtue of not this resolution, but annexure C was cancelled, page 23, dated 27/6/19, but without notice, without hearing the petitioner. But the facts of the case is, but annexure C, page 23, a resolution was taken by the board. Not page 23, annexure C, but relevant page is page 47, my lord.
Item number?
Page 47, item number Y. Vishay. Page 47, my lord.
Why anta ide?
Item number?
Why,
Why, my lord? Why?
WXY anta.
46.
Oh. Sorry, my lord, explain. My lord, here, the board has taken a decision, not allotted, my lord, this site to the extent of 594 ಚದರ ಮೀಟರ್ ಜಾಗೆ ಬಾಟಮ್ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನ ಸಮಿತಿಯವರಿಗೆ ಮೇಲೆ ತಿಳಿಸಿದ ಚಟುವಟಿಕೆಗಳಿಗೆ ಅನುಕೂಲವಾಗುವಂತೆ ಪ್ರಸ್ತುತ ಸಂತ್ರಸ್ತ ಸಂಘ ಸಂಸ್ಥೆಗಳು ಜಾರಿಯಲ್ಲಿರುವ ದರಗಳಂತೆ ಹಂಚಿಕೆ ಮಾಡಲು ತೀರ್ಮಾನಿಸಿದೆ. But this decision was taken by the board. Thereafter, my lord, Annexure D, page 58, subcommittee meeting dated 10/2/21, Annexure D. Annexure D, my lord. Page 50, item number 19.
Annexure D, item number 19.
Item number 19, my lord. But they have allotted, my lord, all the ದೇವಸ್ಥಾನ and item number ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನ ಬಾಗಲಕೋಟೆ ಅವರಿಗೆ ಹೆಚ್ಚುವರಿ ನಿವೇಶನ ಮಂಜೂರು ಮಾಡುವ ಕುರಿತು. ಶರಾ my lord, ಈಗಾಗಲೇ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನಕ್ಕೆ ಸೆಕ್ಟರ್ ನಂಬರ್ 25, 78 ಸಂಖ್ಯೆ ಈ ಮಾದರಿ ನಿವೇಶನ ನೀಡಿದ್ದು, ಸರಿ ನಿವಾಸದಲ್ಲಿ ಬಾಕಿ ಉಳಿದ 594 ಚದರ ಮೀಟರ್ ನಿವೇಶನವನ್ನು ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನಕ್ಕೆ ನೀಡುವ ಕುರಿತು ಪ್ರಾಧಿಕಾರದ ಬೋರ್ಡ್ ಸಭೆಗೆ ಮಂಡಿಸಿ ಉಪಸಮಿತಿ ಶಿಫಾರಸು ಮಾಡಿತ್ತು. But this decision was taken. Then, my lord, Annexure E, my lord, the authority sought for, my lord, the sketch to prepare a sketch in respect of the petitioners, not the grant of, not the site, for, my lord, market price. This decision was not unilaterally withdrawn by the authority, not without notice and without hearing me.
What is the resolution? Tarau at page 69.
Page 69, my lord.
That's just, my lord, we read them.
Page 69, my lord, 12B here. Next, my lord. ಅಧ್ಯಕ್ಷರು ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನ ಸೇವಾ ಸಮಿತಿ ಎಸ್ಟೇಟ್ ಬಾಗಲಕೋಟೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ WP ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದು, ನಿವೇಶನ 77 ಕೂಡ ದೇವಸ್ಥಾನಕ್ಕಾಗಿ ಮೀಸಲು ಇಟ್ಟಿದ್ದರಿಂದ ಅದು ತಮ್ಮ ದೇವಸ್ಥಾನಕ್ಕಾಗಿ ಹಂಚಿಕೆ ಮಾಡಬೇಕೆಂದು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ WP ನಂಬರ್ 77 ದಾಖಲಿಸಿ ಹೆಚ್ಚುವರಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ಕೋರಿದರು. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಹೆಚ್ಚುವರಿ ನಿವೇಶನ ಪಡೆಯಲು ಯಾವುದೇ ವ್ಯಕ್ತಿ ಶಾಸನಬದ್ಧ ಹಕ್ಕನ್ನು ಪಡೆಯುವುದಿಲ್ಲ ಹಾಗೂ ಹೆಚ್ಚಿನ ನಿವೇಶನ ನೀಡಲಾಗುವುದಿಲ್ಲ ತಿಳಿಸಿ ಪ್ರಕರಣ ವಜಾ ಆಗಿದ್ದು ಇರುತ್ತದೆ. ಸದರಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನ ಸಮಿತಿಯವರು ಹೆಚ್ಚುವರಿ ಜಾಗೆಯನ್ನು ಪಡೆಯಲು ಅರ್ಹರಿಲ್ಲವಾದ್ದರಿಂದ 26/7/2019 ಜರುಗಿದ ಪ್ರಾಧಿಕಾರದ 134 ಬೋರ್ಡ್ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ 16 ವಾಯದಲ್ಲಿ ಹೆಚ್ಚುವರಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ತೆಗೆದುಕೊಂಡ ಠರಾವನ್ನು ಮತ್ತು 12/2/2021 ಜರುಗಿದ ಪ್ರಾಧಿಕಾರದ 141ನೇ ಬೋರ್ಡ್ ಸಭೆಯ ವಿಷಯ ಸಂಖ್ಯೆ H15H ರಲ್ಲಿ ಉಪಸಮಿತಿ ನಡವಳಿಕೆಯಂತೆ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೆಚ್ಚುವರಿಯಾಗಿ ಹಂಚಿಕೆ ಮಾಡಲು ತೆಗೆದುಕೊಂಡ ನಿರ್ಣಯಗಳನ್ನು ರದ್ದುಪಡಿಸಲಾಯಿತು. ಮುಂದೆ ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೆಚ್ಚುವರಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡದಿರಲು ತೀರ್ಮಾನಿಸಿದೆ. Lord, this decision was taken. Lord, he also, Lord, applied for plot number 77. For that, Lord, this honorable court, Lord, dismissed the writ petition contending that he is not eligible to get one more Lord site. But here 78 plot was the temple and surrounding area was submerged under the UKP project. For that, Lord, the government took a decision to allot, Lord, certain, Lord, the sites to the religious institution. For that, Lord, part of the portion was allotted. I have put up a temple. Remaining portion was, Lord, in the plot number 78. It remains, Lord, vacant. I am conducting jatra and other functions. Therefore, Lord, I sought for, Lord, grant of remaining portion. The decision was taken in the 2019. That decision was, Lord, when the decision was taken, Lord, instead of, Lord, he pursuing, he was applied for one more plot number 77. That writ petition came to be dismissed. He is not entitled. Therefore,
now the plot allotted is plot number?
Plot number 78, my lord. Annexure B, my lord. Is 78, my lord.
78 ನಿವೇಶನ ಸಂಖ್ಯೆ
78, my lord.
594
ಚದರ ಮೀಟರ್. Lord, in the said plot, my lord, they have initially allotted
yes. Lord,
30 into 60.20 into 30 meters.
Lord, initially, my lord, the land which is, my lord, the temple land is there, my lord. It's situated in Old Bagalkoti, my lord. It was submerged and the land was acquired. My lord, that land, my lord, he was, my lord, compensated in terms of the Land Acquisition Act, my lord. He paid the compensation, everything. This is in addition to that, my lord.
You allotted 78.
78, my lord. Some, my lord, total, my lord, we have allotted 594 square meter land, so that, my lord, he can construct some more temples and that's my lord. Thereafter, my lord, he a request
77 also.
no, 78, 70, after that, my lord,
Uh-huh.
he made a request that my lord, remaining portion, my lord, which is my lord, vacant land, to kindly allot that land also, my lord, even though there is no provision under the law, my lord. That was rejected by the initially, my lord, the government, my lord, the authorities. That was he was challenged before this honorable court.
That was also rejected.
That is, my lord, what his submission that, my lord, it is only with respect to 77, and it is not a 77, my lord. It is 78 also. Prayer, my lord. Direct the first respondent to allot the remaining portion of the site bearing number E78 and E77.
This was on 2017.
17.
So that was a complaint filed by somebody that was upheld by the court. But your allotment that you have made is in 2019.
19.
No, that is not an
27/6,
allotment.
2019, Annexure C.
See, my lord, that's not allotment, my lord. The resolution was passed
Ah.
by the, my lord, the department, by the authorities, board authority.
Yes.
Thereafter, my lord, it was directed to place before the, my lord, Upasamiti. my lord.
Upasamiti has also accepted.
Approved.
No, Upasamiti, my lord, what Upasamiti sabege mandisalu pradhikada board ge mandisalu anta decision ತಗೊಂಡ್ರು.
Page 54, 55.
ಅದೇ 55 ನ ಓದ್ತಾ ಇದೆ ಮೇಡಮ್. ಈಗಾಗಲೇ ಶಿವಲಿಂಗ ದೇವಾಲಯಕ್ಕೆ ಸೆಕ್ಟರ್ 70 ನಿವಾಸ ಸಂಖ್ಯೆಯಲ್ಲಿ ಈ ಮಾದರಿ ನಿವೇಶನ ನೀಡಿದ್ದು ಸದರಿ ನಿವಾಸದಲ್ಲಿ ಬಾಕಿ ಉಳಿದ 500 ಚದರ ನಿವಾಸ ಶಿವಲಿಂಗ ದೇವಸ್ಥಾನಕ್ಕೆ ನೀಡೋ ಕುರಿತು ಪ್ರಾಧಿಕಾರದ ಬೋರ್ಡ್ ಸಭೆಗೆ ಮಂಡಿಸಲು ಉಪಸಮಿತಿ ಶಿಫಾರಸು ಮಾಡಿತು ಅಂತ. ದೇರ್ ಆಫ್ಟರ್ the impugned order was passed saying that there is first of all, my lord, the present impugned order, what it reflect, my lord, there is no provision under the law, my lord,
For allotment.
allotment, my lord. It's true that, my lord, there may be some vacant land is there, but my lord, since, my lord, under the law there is no such provision that, my lord, I had to allot, my lord. This is in addition to, my lord, this is in addition to the, my lord, compensation which he has received. My lord, it is in the year 2007, my lord, after
Compensation ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
Please, madam.
ಅದು ಬಹಳ ಆಮೇಲೆ ತಾವು ಒಂದು ಡಿಸಿಷನ್ ಮಾಡಿದ್ರಿ ಮೇಡಮ್.
There is only a recommendation. Recommendation has been rejected.
Reject.
Without hearing, my lord. Let them, my lord.
Who are you concerned with the recommendation by? It's the internal affairs of the council.
ಇನ್ನೊಂದು there is series matters, my lord, which is filed before this court. The land user requesting, my lord, to allot, my lord, additional land and something, my lord. This court, single judge, my lord, was pleased to allow those writ petition. The division bench ಅಲ್ಲಿ detail ಆಗಿ consider ಮಾಡಿದ್ದಾರೆ. And then, my lord, I brought to my lord's no order before the division bench. And in my lord's order, my lord has rightly observed that it will open the floodgate.
This is already accepted the compensation. There is no question of
granting because there is no rules, my lord. That is
separate compensation. What is the provision under which you can get this allotment?
No. But only, my lord, they took a decision. Now rejection is only on the.
They are considering it was placed before the subcommittee. The subcommittee also recommended, but the council rejected it. Every recommendation cannot be accepted.
Lord, this is not a recommendation.
I'm not entitled for hearing.
Only one.
So first land ಕೊಟ್ಟಿದ್ದು is not entitled.
But my limited prayer is, my lord. Annexure C 2019, my lord, it is in my favor. That was cancelled. Board took a decision. But this
That doesn't give you any right on that basis. You will have to establish your right for this allotment independently for us to consider. Only principle of national justice will succeed agala. Unless you establish a right to challenge that as a resolution of the board.
Lord,
Is your right.
Lord, my right is, my lord, my total extent of, my lord, my property submerged is, my lord, excess. They have allotted less. Therefore,
allotted ಅಲ್ಲ
Allotted, no,
compensation
no, no,
ತಗೊಂಡಿದ್ರಲ್ಲ full
compensation ತಗೊಂಡು apart from compensation ನೋಡಿ they have
there is no.
compensation ತಗೊಂಡು ಇದು ಬೇಕು ಎಲ್ಲ ಬೇಕು ಅಂದ್ರೆ you can't ask for it, Mr. Mudhol. You should have then at that time made the request. Third. You are for all three?
Please, Madam.
Respondents, yes. The petitioner is before this court seeking for the following reliefs. The petitioner is a temple trust, is a religious trust running a temple. Earlier, the temple was in CTS number 217, situated in CTS number 217/A/4 of ಯಾವ village?
Bagalkot.
Of Bagalkot, which came to be submerged under the UKP, in the UKP project. As such, the said land came to be acquired and compensation paid. The petitioner made an application for allotment of a plot for construction of the temple. Initially, the said application was accepted.
And total action 486 square meter, annexure B, page number
annexure
20,
B,
my lord.
annexure B, 16.20 and 30 meters. It was put up construction.
ಎಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ?
Hakkupatra, this is the Hakkupatra, we have put up a construction. Temple was constructed in part of the building area.
In plot number
78.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿದೆಯಾ?
Construction ಆಗಿದೆ.
ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಅವ್ರಿಗೇನು ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ my lord, which is allotted in 2007. Total my lord, we have granted my lord 486 square meter ಕೊಟ್ಟಿದ್ದೀವಿ 2007 ಅಲ್ಲಿ.
ಪ್ಲಾಟ್ ನಂಬರ್ ಎಲ್ಲಿದೆ?
My lord, ರನ್ನಿಂಗ್ ಪೇಜ್ 20 my lord, ಹಕ್ಕುಪತ್ರದಲ್ಲಿ ನಿವೇಶನ ಕ್ರಮ ಸಂಖ್ಯೆ 3ನೇದು E78 ಅಂತ ಇದೆ ನೋಡಿ.
E78.
Yes, 78. ಅದರಲ್ಲಿ ನಾವು ಅವ್ರಿಗೆ ಆಲ್ರೆಡಿ my lord 16 ಕೊಟ್ಟಿದ್ದೀವಿ.
Document in the form of Hakkupatra was issued on 23/7/2007 for plot number E78 measuring
16.20 and
16.20 meter into 30 meters.
Please.
Totally amounting to?
It comes my lord 486 square meter.
486 square meters. Subsequently, the petitioner made an application for grant of remaining portion of the said plot number 78, which was considered in the meeting of respond number 1 on 27/6/2019 and directed to be placed before the subcommittee. The subcommittee, in its meeting held on 10/2/21, recommended the allotment of the remaining portion. When the board took up the matter on 16/7/2021, the board rejected the said recommendation on the ground that there is no particular provision which is available to grant this additional land to the petitioner. It is challenging the same, the petitioner is before this court. The submission of Shri Shivraj Modol, learned counsel for the petitioner, is that the property of the petitioner, which was submerged, measured 896 square meters. What is being allotted is only 473 square meters. And as such, the balanced land in plot number 78 is required to be allotted to the petitioner to build a proper temple and for carrying out religious activities. The submission of G.K. Iregowda, learned counsel, appearing for respond number 1 to 3, is that there is no particular provision entitling the petitioner for grant of any land, grant or allotment of any land or plot. The allotment made earlier was in the development, in the, in the development carried out by respondent number 1, where a layout had been formed in Navanagara, and therein a portion of the land had been identified for construction of a temple. This allotment by itself would not confer any right on the petitioner to seek for additional land, the petitioner having already received the compensation for the submerged land. As such, he submit that the above petition is required to be dismissed. Heard, Shri Shivraj Mudol, learned counsel for the petitioner, Shri G.K. Iregowda, learned counsel for respondent number 1 to 3. It is not in dispute that the petitioner's land is submerged, as regards which the petitioner has received compensation. There is no particular provision which has been brought to the notice of this court indicating the right of the petitioner for allotment of any land after having received compensation, except to contend that there is a vacant land next to plot number 78, which also requires to be allotted to the petitioner. There being no right under any particular law vested with the petitioner for allotment of land, this court, in the earlier round of litigation, in WP number 67712-67713 of 2011, while order dated 8 March 2017, had observed that no further allotment could be made to the petitioner. Such an order having been passed by this court would be binding on respondent number 1 to 3 also, which has been taken note of by the respondent board in its meeting held on 16/7/2021, and a resolution passed rejecting the request of the petitioner. The rejection being in furtherance of the order of this court, the petitioner not being able to establish any particular right under any law for allotment of additional land after having received compensation, no grounds being made out, petition stands dismissed. IA 1/24 stands consigned.
25, Suresh Chettimnawar.
For the respondent, my lord, respondent.
Yes.
My lord, there was a map was prepared by the respondent number 4, my lord. So bifurcate the property which are in the name of petition and respondent number 4 and 5. Same was having before the DDLR, same was rejected. Thereafter, the appeal was referred, and the entire HISA was or HISA was deleted from the records, my lord. And our only contention is that though in the presence of all the property, HISA was prepared, map was prepared, thereafter the AD should not have rejected the said HISA and order for the new map and the HISA, my lord. Only that contention.
My lord, in the year 2006, the respondent number 4 has purchased the 24 Buddha land out of RS number 125/1B, my lord. And subsequently, the ADLR has prepared the map without my knowledge, and they have prepared 5 visas, my lord. And I have challenged the said 5 prepared by the map before the ADLR road. The ADLR rejected, the DDLR has rejected my appeal. Then I prepared the revision petition before the JDLR Belgaum, my lord. Considering my appeal and the error committed by the respondent number 3, the JDLR has rightly passed the order, my lord, and given opportunity to both the parties, fresh such as prepared, my lord.
Place all the documents before the JDLR so that all these details could be ascertained, and he informed that this one.
My lord, JDL clearly directed to
Petitioner is before this court seeking for the following reliefs. The petitioner claims that the land in survey number 125/1 capital A, measuring 4 acres 6 guntas, situated in Mushigiri village, Gajendragarh Taluka, belong to the grandfathers of the petitioner and respondent number 5 and their brothers. Due to many of them expiring, many changes were made in the revenue records, contending that the petitioners are in possession of certain land as regards which entry has been made in favor of respondent number 5, the petitioners challenging the ISA document in respect of survey number 125 stroke 1 capital A, 1B, 3 and 4, preferred an appeal before the DDLR who rejected the appeal. The petitioner filed a revision petition before the regional joint director of land records, who allowed the revision petition, set aside the ISA documents and remanded the matter for fresh measurement and preparing of ISA documents. It is challenging the same. The petitioner is before this court. It is not in dispute. The ownership of the properties are not in dispute. The expiry of the several persons who were earlier the owners is also not in dispute. Thereafter, there have been certain partitions and documents entered into between the parties, dividing the properties among themselves. The contention being that the entries made in the ISA document by the respondent number 4, by respondent number
3, my lord.
3, not being proper, the regional RJDLR, by accepting the revision petition, has remanded the matter to the DDLR for carrying out a fresh survey on the basis of the documents which are furnished
By issuing all the notice to
by
the respondent.
all the
parties.
all the persons who have an interest in survey number 125. I do not find any infirmity in the same. Both the petitioner and the respondent number 4 and 5, as also any other person interested in the said property, would have to be issued notice by the DDLR, and after receiving necessary any documents that the parties may furnish, considering the said documents, carry out a survey and fix the boundaries and make necessary entries in the ISA 40 document. As such, with the above observation, the petition stands disposed.
Please, my lord.
Pending IA stands.
26, Venkatesh Karvi.
Regarding the grantee need, my lords, my colleague, Mr. Parthsarthi in VC, my lords. Kindly pass, otherwise pass over, my lords.
Pass over.
Please.
27, Santosh Raut.
Please, Milan.
Lord, I am appearing for the
Pavan Dodatti.
respondent.
Yes.
Lord, kindly ask matter on Monday, my lord.
Lord, they have taken the injunction order. Pursuant to that, they are disturbing our possession. We filed suits.
At the request of Sri S.C. Booty, released on 27th, it is made clear that no further adjournment would be granted.
My matter, there is an interim order which has to be.
Interim order earlier granted is extended till next day.
Of less.
28, Santosh Nargund.
For the petitioners council, my lord.
Yes. Report of the ADLR.
Yes, but your lordship, as per the information, that no report is submitted, your lordship.
No report is submitted. Now can the order be passed? If no report is submitted, how can he mention that?
ಅಲ್ಲಿ ಇನ್ನೂ ಸ್ವೀಕೃತವಾಗಿರೋದು ಅಂತ ಬರ್ಬಿಟ್ಟಾರೆ ಪ್ಯಾರಾ ಇಂಕ್ ಪೇ 69 ಅಲ್ಲಿ ಪೇ ನಂಬರ್ ಇಂಕ್ ಪೇ 69 ಪ್ಯಾರಾ 8 ದಲ್ಲಿ ರಿಪೋರ್ಟ್ ಈಸ್ ನಾಟ್ ಸಬ್ಮಿಟೆಡ್ ಅಂತ ಹೇಳಿ
ಪ್ಯಾರಾ
8 ದಲ್ಲಿ ಇಂಕ್ ಪೇ 16 ಲಾಸ್ಟ್ 2 ಲೈನ್ಸ್ ಇಲ್ಲ
ಎಸ್
ಅದರಿಂದ ನಕ್ಷೆ ತಯಾರಿಸಿ ವರದಿ ಸೂಚಿಸಿದ ಪ್ರಕಾರ ಈವರೆಗೂ ಯಾವುದೇ ವರದಿ ಸದನದಿಂದ ಸ್ವೀಕೃತವಾಗಿರುವುದಿಲ್ಲ. On that basis, of the JDLR has passed the order.
29/8/2002
Yes.
ಸ್ಥಳ ಏನು ನಕ್ಷೆ ತಯಾರಿಸಿ
Yes.
ವರದಿ ಸಲ್ಲಿಸು ಕರಾರ್ But why is he referring to this?
But it is the report submitted by the, that is the letter written by JDLR, Hubli Your Lordship. But regarding so far, Your Lordship, Joint Director, Your Lordship, I have not received any information. That is the.
ಇವಾಗ ರಿಪೋರ್ಟ್ ಇದೆಯೋ ಇಲ್ವೋ?
But regarding that, I am not received. But Your Lordship, but what happened, Your Lordship, the JDLR Hubli has written letter, this letter. JDLR Hubli has written this letter. That Your Lordship, report is not submitted. But Your Lordship, in the order passed by the JDLR Belgaum, where Your Lordship report is not received ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಹುಬ್ಳಿ ಅವ್ರಿಗೆ ಏನಕ್ಕೆ ಕೇಳಿದೆ? ಬೆಳಗಾವಿ ಹತ್ರ ಕೇಳಿದೆ.
ಇಬ್ಬರಿಗೆ ಕೇಳಿದೆ ನಾವು.
ಯಾಕೆ ಇದು
But
pass
ಅವರು ಯಾಕೋ
ಮಾಡಿರೋದು ಬೆಳಗಾವಿ ಮಾಡಿರೋದು ಇದು?
ಹೌದು. I have written letter to both Your Lordship.
ಅವ್ರು ಏನು ಇನ್ಫಾರ್ಮೇಶನ್
ಬಂದಿಲ್ಲ. Monday Your Lordship, I have written Monday.
This is the only thing, that in spite of he himself observing that so far that report is not received, he proceeds to pass an order in the absence of that report. So therefore, it's a case where it can be set aside.
Your Lordship, we have written both Your Lordship, Hubli and
we'll set it aside. If there's a report, get a report,
yes.
Furnish it to them, they can make their submission on it, pass orders. Petitioners are before this court seeking for the following reliefs. The petitioners claim to be the legal representatives of late Vincent Devapriya Kirby, who was the owner of the land in CTS number 3116, bearing revenue survey number 58, situated at Unkal village, Hubli. Respondent number 3 had claimed to be the owner of RS number 58/3B under a sale deed dated 16/12/91. The petitioners, however, contend that the claim of respondent number 3 is as regards property belonging to Hubli Dharwad Municipal Corporation and not the petitioners. And in fact, HDMC had issued a notice under section 321 of the Karnataka Municipal Corporation Act to respondent number 3. Respondent number 3 had filed a revision petition in CTS revision number 58 of 2017-18 before respondent number 1, Joint Director Land Records, City Survey North Zone, Belgavi, to set aside the mutation entry of the petitioners and by holding that his property is covered in RS number 58 without making the aforesaid Vincent Devapriya Kirby a party to the said proceedings. Respondent number 4 had filed objections to the revision petition. Respondent number 1, by order dated 26/2019, directed the ADLR and land revenue officials of Hubballi to conduct a joint spot inspection and submit a report. Respondent number 1 had in the meanwhile also filed a complaint before the Anti-Corruption Bureau alleging there is manipulation of documents in CTS number 3116 and 3121. And subsequently, by order dated 26/9/2019, allowed the CTS appeal. Challenging the same, respondent number 4 had filed WP number 114504 of 2019. Adenaita writ petition,
Well, it was sought to be withdrawn, and
which
Your
came
Lordship
to
was
be
pleased
withdrawn
permit,
on
with
14/12/2023. The petitioners had sought to implead
Please,
in the said petition were granted liberty to independently challenge
please,
the order, and as such, the petitioner are before this court challenging the same.
please.
The submission of learned senior counsel appearing for the petitioner is that in the impugned order dated 20, that though respondent number 1, wide order dated 26/2019 had directed the ADLR to carry out a joint inspection and submit a report. In the impugned order dated 26/9/2019, respondent number 1, having observed that there is no report submitted, has gone ahead and passed the order. And as such, the rights of the petitioner have been adversely affected without a spot inspection, joint spot inspection having been conducted in the presence of the petitioner, and the documents submitted by the petitioners have not been considered.
Please.
It is in that background that this court had on 8/1/2025 called upon the learned AGA to inquire into, obtain instruction, make a submission as to whether a report had been submitted or not. Today, learned AGA submits that no such report has been submitted on the basis of the instructions provided by the ADLR.
Hubli.
The letter, the respondent number 1, wide letter dated 26/2019, had directed the ADLR Hubballi to carry out such joint inspection. Now that the ADLR Hubballi has categorically stated that no such report has been submitted, it was for respondent number 1 to have awaited the said report before passing orders. Not having done so has resulted in violation of the principle of natural justice, depriving the petitioner of a right to make his submission, petitioners to make their submission. In that view of the matter, I pass the following order. Writ petitions allowed, certiorari is issued, so and so is quashed. The second respondent, ADLR, is directed to carry out a survey of CTS number 3116 and 3121, commencing from 10:30 a.m. on 31st January 2025. Demarcate the boundaries thereof, ascertain the survey numbers relating to the said CTS numbers, demarcate the boundaries thereof, obtain the necessary documents from the relevant sub-registrar's office, as also the revenue documents relating to the said properties, correlate the same to the extent of lands demarcated in the said CTS number, and submit a report in relation thereto on or before 14th February to the first respondent, who shall then consider the same and pass necessary orders after providing an opportunity of hearing to the petitioners. Since the order is passed in the presence of the petitioners, respondent number 3 and 4, having chosen not to appear before this court, there would be no requirement of notice to be issued to the petitioners. However, respondent number 2 is directed to serve notice on respondent number 3 and 4 by hand delivery before the survey is carried out.
And the HDMC also. HDMC also, because the part of the property belongs to HDMC is the finding
as also
record
to the HDMC.
Please.
Before the survey is carried out. During the course of the survey, if the ADLR were to be of opinion that any other person is interested
Please.
in the said land, the ADLR would have to issue notices to such persons
Please.
also and conduct a joint survey, even if already conducted on 31st January.
Please.
Pending IA stand disposed.
29, Dharwad.
For the respondent number 1, Lordship, I have filed vacating the interim order.
have challenged I number 15 access.
Oh, really?
Please,
I mean,
please, Lord.
I number 50, annexure F, Malad, my
suit
application.
for,
Suit for partition and separate position filed by the respondent number 1.
hmm,
Against the Malad, the dependents. The Malad, the petitioner is Malad, the proposed dependent number 4.
proposed dependent.
How?
Purchaser, huh?
No, Malad, is in the family partition in the year 2011, Malad, that one of the suit property is fallen to the Malad, the proposed dependent number 4. Malad, the page 54 for a moment, kindly see Malad, page 54.
Yes.
The plaintiff filed the application I number 5 in Malad, for paper publication for issuance of notice to the Malad, proposed dependent number 4. Malad, the date of appearance is Malad 2/12/2019. Malad, the paper publication Malad issued in Kannada Prabha Daily in Belgaum edition. Is Malad, at present Malad resident at Bangalore. Malad, place ex parte Malad 2/12/2019.
Who are you?
Malad, the son of Malad, the dependent
Number 1 and 2.
1 and 2.
What objection do you have?
Malad, my application is rejected. Ex parte Malad, seeking Malad, the setting aside the Malad ex parte order that is rejected by the trial court.
Next. So you want to now come on record?
Please.
Let him come on record.
Lordship, he is the son of the member 1 and 2. After his majority lordship, he filed application on 2/12/2019. Ex parte. Now he is a resident in his affidavit. He is a resident of Khathra village.
Delay account ಕೂರ್ಸ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ. He is now. Lordship, in his affidavit, I number 15 is affidavit. He is stating that he was resident of Khathra village. No, he is not a Bangalore.
We'll allow you this. Let him be a party and file his. Petitioner is before this court seeking for the following relief. Respondent number 1 had filed a suit in OS number 126 of 2017 seeking for.
Moreover, defendant number 1 and 2 are the parents of the said proposed respondent number 4 lordship.
Position. In the said suit, the plaintiff filed an application to implead the petitioner as
Dependent
number 4. Proposed
number 4. Notice having been taken out, the petitioner not having appeared was placed ex parte and the matter proceeded with. The petitioner filed an application on
application filed on
ex parte
I number
ಯಾವ್ದಾಗಿದ್ದು?
15. Ex parte 2019 ಒಳಗೆ 2/12/2019 lordship.
Please filed
Now
on
he's-
5/4/2024.
Appeal filed on, he filed petition on the I on 2024. In that he has residence of Khathra village lordship. But now he stated that he was in the Bangalore. He is agriculture, he is not a student. Stated agriculturist in the affidavit. I
ಏನು
number
stage ಏನಿದೆ?
Stage depend Malad, the cross examination of DW1.
DW2.
DW2.
ಅದಕ್ಕೆ ಇವಾಗ ಬಂದು ಹಾಕಿದ್ದೀರಾ?
Allah, his right is not, his parents are already on record lordship. His right is satisfied.
Why did you file the application?
No, I have filed in 2019 lordship.
You filed the application to bring him on record. His right is not affected ಅಂತ ಇವಾಗ ಹೇಳಕ್ಕಾಗತ್ತಾ ನೀವು?
Allah, I am for the plaintiff lordship.
ಅದೇ ನೀವು ತಾನೇ ಅವ್ರನ್ನ ಇನ್ವೈಟ್ ಮಾಡಿ.
ಅದೇ ನಾವೇ ಮಾಡಿದ್ದು.
They are not affected ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಡ್ದಾಗಿತ್ತು.
ಅವ ಮೇಜರ್ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ when did you file the application?
5/4/2024. 5/4/2024.
I number 15 lordship. Annexure F, page number 39.
Page 39.
Page 39.
Order sheet ಅಲ್ಲಿದೆ. 5/4.
Order sheet page number 91 lordship.
Page 91.
I had filed an application and order 9 rule 7 to set aside the ex parte order on 5/4/2024, which came to be dismissed by imposing cost of rupees 200 on the ground that the order of placing the defendant number 4 ex parte was passed on 2/12/2019 and the application had been filed after 5 years on 5/4/24. ನಿಮ್ಗೇನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. You are Parents have. Your father has
Already they
later
have filed a written
Malad,
statement.
in the year 2011, in the Malad, the family arrangement, one of the suit property Malad, the followed to the Malad share of the Malad, depend number 4.
It is showing same petitioner is before this court. Shri H.M. Darigaon, learned counsel for the petitioner submits that the notices which have been issued were to the address in ಯಾವ address ಕೊಟ್ಟಿದ್ದು
2011.
ಅಲ್ಲ paper publication was taken out
Paper
in
publication Malad issued.
Kannada Prabha, Lord.
Kannada Prabha daily newspaper.
Kannada Prabha ಯಾವ
Belgaum edition, Lord.
in Kannada the paper publication taken out in Kannada Prabha Belgavi district while the petitioner is a resident of Jakasandra HSR layout Bengaluru and therefore the petitioner did not have knowledge of the said paper publication and could not appear. Which fact he submits has not been taken into consideration by a trial court. And counsel for the respondent would however oppose the contention by contending that the father and mother of the petitioner being already on record, the petitioner being only a student, the father and mother could have informed the petitioner about the said application. The petitioner has chosen to delay the proceedings by not appearing in the matter, and now when the matter is posted for cross-examination
DW2, Lord.
of DW2,
Please.
an application for setting aside ex parte has been made, which is only to protract the proceedings. And on that ground, he submitted the above petition. Actually, in dismiss ಮಾಡಬೇಕು. ಅಪ್ಪ ಅಮ್ಮ ಇದ್ದಾರೆ, ನೀವು 23 ಸ್ಟೂಡೆಂಟ್.
Was student at
Malad,
the time.
the himself Malad, the implead with the Malad, the petition.
Implead one, ನೀವು ex parte ಆದ್ಮೇಲೆ why should we permit you now after 5 years?
Up to 5 years Malad, the
ಅಪ್ಪ ಅಮ್ಮ ಹೇಳಿಲ್ವಾ ನಿಮ್ಗೆ
ಅಲ್ಲ ಇದಾರೆ
ಚೂಟಿದೆ ಅಂತ?
ಇಲ್ಲ ಹೇಳಿಲ್ಲ ಬರೀ ಇದು Malad, the study at Malad,
Funding your education. Who is funding your education?
father and mother.
ಮತ್ತೆ? We won't allow this.
Malad, the reason assigned by the for a moment.
You are a student. ನೀವೇನೋ 2011 ಅಂದ್ರೆ you are some 50
ಅಲ್ಲ,
years,
Malad,
you are
ಈ-
separated ಅನ್ಕೊಂಡ್ವಿ.
ಅಲ್ಲ
You are not
for a
separated.
subsequent date for a moment kind
Even that partition is hogwash.
The parents are there, Lordship. Their share, you get the share.
That is also
for a
only
moment kind
hogwash.
Malad, the next page 57.
Sorry.
Malad, the dispense notice dispense with
ಯಾರಿಗೆ?
trial court to the depend number 4 for page 57.
Dispense with the paper publication ಆದ್ಮೇಲೆ dispense with India.
Subsequently Malad, the issue summons Malad, the to the Malad depend number 4 page 57 for a moment kind Malad.
Issue suit summons to defend number 4 through RPID.
Please, the amendment is reported carried out and the amendment plaint is supplied. Issues suit summons to depend number 4 through RPID. Call on 13/1/2020. Then Malad, the depend number 4 is absent. The summons returned to the unserved by considering the previous status of summons against the depend number 4 is dispensed with. On Malad, the 31/1/2020.
Paper publication ಆಯ್ತು
Paper
ತಾನೇ?
publication ಆದ್ಮೇಲೆ issue summons to the
Your
Malad depend number
parents are
4.
there, Mr. Adhari.
ಅಲ್ಲ subsequently summons issued to the depend number 4.
Heard so and so, peruse papers. Even according to the petition, the petitioner is a student and the son of respond number 2 and 3 year in,
Please, Lordship.
who are defend number 1 and 2
Before the
in OS number
126 of 2017.
126 of 2017. The father and mother of the petitioner being parties to the said suit, it is improbable that the pendency of the suit is not made known by them to the petitioner who is their son. Though the contention of the petitioner is that the petitioner is studying in Bangalore, the fact remains that the permanent residence of the petitioner is with his parents in Saudatti, Belgavi. If that be so, the paper publication taken out in Kannada Prabha Belgavi edition cannot be faulted with. The manner in which the petitioner was placed ex parte the petitioner having been placed ex parte in the year 2019, the manner in which the application has been filed in the year 2024, when the matter was posted for cross-examination of DW2, would only indicate that the petitioner and defendant number 1 and 2, his parents, want to protract the proceedings and delay the matter by now getting the petitioner to come on record, file his written statement, and derail the proceedings before the trial court which have taken place. A perusal of the order sheet also does not inspire any confidence insofar as the conduct of defendant number 1 and 2 are concerned, inasmuch as they have taken several adjournments to cross-examine the plaintiff, and they took several adjournments to lead their own evidence. Further, they were not present when posted for their cross-examination. And it is at this stage that the application for setting aside the ex parte order of the petitioner had been filed. In that view of the matter, I am of the considered opinion that the application was filed only to protract the proceedings, the petitioner having full knowledge of the pendency of the proceedings has chosen not to appear in the matter. The trial court has been lenient enough to impose only 200 rupees cost on the petitioner. This court is of the opinion that higher cost would have to be imposed, and as such imposes cost of rupees 5,000 to be paid to the advocate clerks so and so within a period of 10 days from the date of this order, that is on or before 6th February.
In the meanwhile, Maladi, fix the date for Maladi in the minute, come on record Maladi.
You are expert. Petition stand dismissed.
In so far cost is concerned, Maladi.
ಇನ್ನ ಜಾಸ್ತಿ ಕಾಸ್ಟ್ 5 ವರ್ಷಕ್ಕೆ 5,000 ಅಂತ ಹೇಳಿರೋದು ಅಷ್ಟೇ. ಎಲ್ಲ ಮಾಡ್ಬಿಟ್ಟು you want to set up not everything.
30 Vidya Raghavendra Rao.
Super petition 6 weeks time, Maladi.
At the request of counsel for the, on behalf of the counsel for the petitioner, request for adjournment is made. Released on 7th February.
Interim order.
Interim order earlier granted is extended to next year.
31 urgent, 32 HM Dharwad.
Okay, for petitioner. The sought for direction to the Maladi swan number 4 to implement the order passed by the Maladi Tahsildar as per Annex J. Annex J page 41 for a moment, kindly see Maladi.
Dodgowda, you are appearing for 7 to 9.
Please.
Who are 7 to 9?
We are the owners of
The owners of the land owner. The land bearing survey
Owners
number.
of the?
Land bearing survey number
74.
74.
74, 75.
Maladi, there is a dispute regarding Maladi pathway Maladi in the land.
Our land trench ಮಾಡಿದ್ರೆ ನೀವ್ ಹೆಂಗ್ madam?
Maladi, there is a public road. In view of the circular Maladi, power delegated to the Tahsildar to Maladi settle the dispute regarding Maladi pathway. Maladi,
ನಿಮ್ pathway close ಮಾಡಿ trench ಮಾಡಿದ್ದಾರೆ.
ನಾನು ಮುಂದೆ ಹೋಗ್ಲಿಕ್ಕೆ ದಾರಿನೇ ಎಲ್ಲ ಕಟ್ ಮಾಡಿದ್ದಾರೆ ರೋಡ್. ಅದಕ್ಕೆ ಈ ಫೈಲ್ಡ್ ಕಂಪ್ಲೇಂಟ್ ಬಿಫೋರ್ ದಿ ತಹಶೀಲ್ದಾರ್ pass an order as per Annex J. To implement that order. Now is Maladi, the road is closed.
Where is that order? Annex J.
Annex J Maladi. Page 41.
Have you challenged this order?
Please, I filed a writ petition. One
No,
more.
writ petition is dismissed. How to dismiss for non-prosecution?
Please.
Challenge ಆಗಿ ಏನಾಗಿದೆ? Annex J is attained finality or?
Subsequently, the very Tahsildar Harapnali has passed, conduct a survey. Conduct a survey. Has filed a report. My submission is, as per the map, I don't have any objection to ingress and egress. ಅವರು ನನ್ನ ಆಸ್ತಿಯಲ್ಲಿ ಎಂಟೈರ್ ರೋಡ್ ನ 74 ಅಲ್ಲಿ ತರ್ತಾ ಇದ್ದಾರೆ. 74 ಕ್ರಾಸ್ ಆಗಿ 66 ಗೆ ಅದು ರೀಚ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. 66 ಇಸ್ ದಿ ಪ್ರೆಸೆಂಟ್ ಪೆಟಿಷನರ್ ಲ್ಯಾಂಡ್. ಫಾರ್ ಅ ಮೂಮೆಂಟ್ kindly see lord. This is the map. 74 ಇಲ್ಲಿ 74 ಬರುತ್ತೆ. This is 66. This is the ಚಕ್ಡಿ ರೋಡ್. ಅವರು ಎಂಟೈರ್ ನನ್ನ ಲ್ಯಾಂಡ್ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು ಅಂತ ಅವ್ರದ್ದು, 74 ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು ಅಂತ ಅವ್ರದ್ದು.
Yes, Mr.
Even I have filed an
They are
objection.
annexed E malad series malad.
When I have filed an objection, I have no objection to
There is a public road
ingress and
from
egress by the petitioner if
E series
as per the map.
photos.
This map is prepared on what basis?
On the basis of village map lots. Village map, entire village map. There is no road as per their
Were
contention.
you present when this survey happened?
No, malad in 2024 itself malad Tahsildar after malad considering the objection, pass an order.
Pass on.
ಹಿಂಗೆ ಎರಡು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಅಂತ
ಅಲ್ಲ, ಅವರು ಓನ್ಲಿ ಆನ್ ದಿ ಬೇಸಿಸ್ ಆಫ್ ದೇರ್ ಕಂಪ್ಲೇಂಟ್ ದೇ ಹ್ಯಾವ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್.
ಮಾಡ್ತಾರೆ.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಸ್.
ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ
ಅಲ್ಲ, ಅದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದಾಗ ದೇ ಹ್ಯಾವ್ ಕಂಡಕ್ಟ್ ಎನ್ಕ್ವೈರಿ. ದೇರ್ ಆಫ್ಟರ್ ಸಬ್ಮಿಟೆಡ್ ಎ ರಿಪೋರ್ಟ್.
Tahsildar has to give an explanation which is correct and which is not correct.
And it is on public
The
road.
grievance of the petitioner is that the order dated 16/5/2024 at Annexure J has not been implemented. The submission of Land Council for respond numbers 7 to 9 is that post the said order, a survey has been carried out and a report submitted on 1/7/2024 indicating that the road, that the pathway, ಏನಿದು ಬಂಡಿಜಾಡ ಏನಿದು
ಬಂಡಿದಾರಿ ಇದೆ ಅಂತ ಅವರು ಒಪ್ಕೊ, ಈ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಬಂಡಿದಾರಿ ಇದೆ ಅಂತ ಹೇಳಿ.
Yes, yes, ನೋಡಿ.
ಇದರಲ್ಲಿ ಬಂಡಿದಾರಿ ಇದೆ ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ.
ಅದೇ 74 and 66 ಅಲ್ಲಿ ಇದೆ.
is not entirely situated in survey number 74 but also goes through survey number 66. Both the report, both order at Annexure J and the report now produced by Council for respond number 7 to 9 are contradictory. Learned AG is directed to secure instruction, make a submission as to which one is correct. And if one of them is incorrect, how the same was issued. Released on
Please.
7th February.
In the meanwhile, malad is sought for interim order. Malad the complete
no,
road
entire my land ಒಳಗಡೆ ಅವರು
unable to malad lift the malad agriculture crops malad.
Released on 1st February.
Please.
33 Vittal Teli.
Request for short date. In this connected matter, I undertake to appear on notes. Sharad Magdum's name is deleted. My name will be shown. I'll file a power note.
You are Sharad Magdum illa, you are appearing.
I am appearing.
Shri 33, Shri Vittal Teli has filed Wakalatnama for the petitioner. Hence registry is direct, delete the name of Shri Sharad V. Magdum as that appearing for the petitioner.
Connected matter, my lords, and I received today my lords file and everything. His name is shown there. I have other lativat bandit.
33.1, Shri Vittal Teli submit that he has received the no objection Wakalatnama today.
Yes.
And he will be filing the same during the course of the day. Registry is directed to print his name as that appearing for the petitioner and delete the name of Shri Sharad V. Magdum as that appearing for the petitioner.
So I request for.
He seeks for and is granted a week's time to comply with office objection. Office objection, if not complied by 31st, released on 5th for dismissal.
34 Ravi Balikai.
Yes, Mr. Vadikai.
Name of the petitioner's husband was entered way back in 1981. Not after death of her petitioner's husband, name of her petitioner has been entered in 2006-7. Lord, this was questioned before the Assistant Commissioner after 35 years by the respondents by filing an appeal under 136(2).
Was there any stay order in
I will just
earlier
submit.
proceeding?
This honorable court will not set aside that order of the Assistant Commissioner and Deputy Commissioner on the ground that the inordinate delay of 35 years without condoning it, the appeal could not have been entertained, and the matter was remitted to the Assistant Commissioner, directing the parties to appear on a particular date. The order is notes at page number 58, last page. Annexure K minutes. 58 minutes. 58.
58. Yes.
The party shall appear before the respondent number 2 on 17/2/22. And the previous penultimate para, my lord, the case is remitted back to the respondent number 2, who shall consider the application for condonation of delay and thereafter pass appropriate order in the light of the decision rendered by the Honorable Court, my lords.
Yes.
My lord, thereafter, my lord, on that day, on 17/2/22, this lady, my lords, who is aged about 75 years, through her advocate and herself, they appeared before the Assistant Commissioner. The papers were not received. They submitted, they said that they will issue fresh notices after receipt of the papers. Thereafter, without issuing notice, the Assistant Commissioner proceeds to pass order saying that the Honorable High Court has directed him to condone the delay, he condones it.
Where is?
That's Annexure B, my lords. Page number 28, relevant page.
Where is the High Court said condone the delay?
That's the understanding of the Assistant Commissioner.
Consider on the
You
state.
can always say
28.
that, but if the.
Really futile, my lords, the way, my lord, the authorities are functioning, much requires to be said. And this is confirmed by the Deputy Commissioner.
Number 1 to 4. The order early condonation.
My lords, page 28 is the impugned order, first order, original order passed after remand.
Limitation mele.
Limitation mele. The present order, my lords. Page 28.
28. Where does it say High Court has said condone?
My lords,
Second para.
ಪ್ರಕರಣದ ವಿಚಾರ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಪ್ರಕರಣ ವಿಚಾರಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ವಾದಿಸಿದ ಅಂಶವೇನೆಂದರೆ ವ್ಯಾಜ್ಯದ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಧಾರವಾಡ ಇವರ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸ್ವಯಂಸ ಪ್ರಕಾರ ದಿನಾಂಕ ಸ್ವಯಂಸ ಪ್ರಕಾರ ಆದೇಶಿಸಿದ ಪ್ರಕಾರ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಕಾಲ ವಿಳಂಬ ಮನ್ನಾ ಮಾಡಲು ಅಂಗೀಕರಿಸಲು ಕೋರಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿಗರು ವಿಚಾರಣೆಗೆ ಗೈರು ಹಾಜರಾಗಿದ್ದು he did not issue notice thereafter, my lords. ವಿಲಿಖಿತ ಹೇಳಿಕೆ ಹಾಗೂ ವಾದ ಸಲ್ಲಿಸಿಲ್ಲ. ವಾದಿಯವರ ವಾದವನ್ನು ಆಲಿಸಲಾಗಿ ಕಡತವಲ್ಲ ದಾಖಲೆ ನೋಡಲಾಗಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಧಾರವಾಡ ಇವರು ರಿಟ್ ಪಿಟಿಷನ್ದಲ್ಲಿ ಸ್ವಯಂಸ ಆದೇಶ ಪ್ರಕಾರ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಕಾಲ ವಿಳಂಬವನ್ನು ಮನ್ನಾ ಮಾಡಬೇಕಾಗಿರುವುದರಿಂದ. That's all. This is the understanding of the Assistant Commissioner. And this order is
on the High Court.
This order is confirmed by KIAS cadre officer, Deputy Commissioner in revision, Annexure A.
ಯಾರೋ ಬರೀತಾರೆ ಯಾರೋ ಸೈನ್ ಮಾಡ್ತಾರೆ. And AG accepts notice for respond number 1 to 4. Issue emergent notice to respond number 5 to 9. The operation execution of the order dated 4/4/24 passed in so and so at Annexure A and order dated 29/8/23 at Annexure B is stayed till the next date of hearing. Respond number
5 to 9.
2 is directed to file an affidavit indicating as to by which order this court had directed the Assistant Commissioner to condone the delay in filing the revision. The said affidavit to be filed on or before 5th February. Process fee and copies to be furnished by end of day 27 January, failing which the interim order will stand automatically vacated. Returnable by issue notice to respond number 5 to 9. Returnable emergent notice returnable by 18th February.
PF by 27/1.
27th.
35, D. Venkan Gowda, party in person.
You're ಇದು ರಿಜೆಕ್ಟೆಡ್ ಇದು ಅಲೌಡ್ ಅದರಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಇದು ಆಲ್ ಆಫ್ ದಟ್ ಇದರಲ್ಲಿ ಫಾರ್ಮ್ ಸಿ ಬಂದಿದೆ. ಫಾರ್ಮ್ ಸಿ ಬಂದಿದೆ ನಿಮಗೆ.
ಹೌದು.
ಹಾ ಹೇಳಿ.
ನ್ಯಾಯಾಧೀಶರ ಪ್ರಾರ್ಥನೆ. ಈ ದಾವೆಯನ್ನೇ ಈ ಕರ್ತವ್ಯ ವಿಶೇಷ ಕರ್ತವ್ಯ ನಿರ್ವಹಣೆ ಒಳಗಡೆ ಸಲ್ಲಿಸಿದ್ದವರು ಅದು ನೆಕ್ಜರು ಜೆ ಪ್ರಕಾರ ಅದನ್ನೇ ಎನೆಕ್ಸರ್ ಸಿ ಪ್ರಕಾರ ಚೀಪ್ ತಗೊಳ್ಳೋ ಕಾಲಕ್ಕೆ ಅದು ಅವಾಗೇನೆ ಈ ಎದುರಾಳಿ ವಕೀಲರು ಇಲ್ಲ ಡೆಫಿಸಿಟ್ ಅಂದರು ಯಾವ ಪ್ರಕಾರ ಅಂದ್ರೆ ಕೇಳಿಲ್ಲ ಜಪ್ತಿ ಅದ್ರ ಪ್ರಕಾರ ಅದನ್ನ ವಿಚಾರ ಮಾಡ್ಲಿಕ್ಕೆ 10 ವರ್ಷ ಅದಕ್ಕೆ ಕಾಲ ಹೋಯ್ತಿದ್ದೇವರು. ಅದಕ್ಕೆ ಮತ್ತೆ ಇಲ್ಲಿ ಆಮೇಲೆ ನೆಕ್ಜರು ಡಿ ಪ್ರಕಾರ ರಿಟ್ಟಿಸೋದಕ್ಕೆ ಹಾಕಿದ್ದೇವೆ ಇಲ್ಲಿ. ಅವರು ಇಲ್ಲ ಅದು ಡೆಫಿಟ್ ಇಲ್ಲ ಸರಿ ಇದೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ಆದೇಶ ಮಾಡ್ತಿದ್ರು.
ಇನ್ನ ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡ್ಬೇಕು ಅಂತನಾ ನೀವು? ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡ್ಬೇಕು
ಅಂದ್ರೆ ಇದು ಅದು ಏನ್ ಮಾಡ್ತಿದ್ದೇವರು ನೆಕ್ಜರು
issue notice to respondent returnable by 25th February. The further proceedings in OS number 97 of 2010 pending on the file of the JMFC Arapnalli is stayed till the next date of hearing. Process fee and copies to be furnished by end of date 27 January, failing which the interim order will stand automatically vacated. 27th ಒಳಗೆ process fee and copy ಕೊಡಿ, ಇಲ್ಲಾದ್ರೆ interim order vacate ಆಗೋಗುತ್ತೆ.
ಇವತ್ತೇ ಕಟ್ಟುತ್ತೆ.
36 Sabil Ahmed.
Of mandamus, my lord, sole respondent, my lord, consider the representation and issue me the form number 3 and the computerized pani.
In representation?
Consider my representation to issue form number 3 and computerized pani. As admittedly petitioners are the owners of the property in question.
I am appearing on behalf of Anand Kolli. We will consider lordship stipulate.
ಯಾರ ಹೆಸರು ಬರಿಬೇಕು?
Anand Kolli ಅವರು.
Shri Anand Kolli accepts notice for respondent. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the absolute owner of the property bearing plot number 1005, 1006, 1007, situated within the town municipal limits of Kamlapur. The petitioner, the kata of the property standing in the name of the petitioner and the petitioner having made payment of taxes. The petitioner, e kata na?
Computerized pani and form number 3.
Submitted. ಇದಕ್ಕೆ ಫಾರ್ಮ್ ಇಲ್ವಾ ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಪಾಣಿ ಕೊಡಕ್ಕೆ
ಇಲ್ಲ ಫಾರ್ಮ್ ಇಲ್ಲ ಮಿಲ್ಟ್, ಅದು ಅಪ್ಡೇಟ್ ಆಗಿದೆ ಇಲ್ಲ ಪುರಸಭೆಯಿಂದ ಇದಕ್ಕೆ ಅಪ್ಡೇಟ್ ಆಗಿದೆ, ಅದು ಅದಕ್ಕೆ ಅಪ್ಡೇಟ್ ಯಾರು ಕೊಡ್ತಾ ಇಲ್ಲ ಕಂಪ್ಯೂಟರೈಸ್ ಪಾಣಿ.
ಯಾವ್ದು ಫಾರ್ಮ್ ಇಲ್ವಾ ಅದಕ್ಕೆ? ನೀವು ಲೆಟರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಹೆಂಗಾಗತ್ತೆ?
Representing with respect to Milord issuance of computerized pani, there must be, there should not be a form, Milord. With respect to form number 3, Milord, I need to file application before the authorities. I'll do the needful with respect to form number 3, Milord, not with respect to
issuance of computerized record of rights and property register card on yavattu?
Annexed D, Milord, page 61.
On 17/8/2024. Grievance of the petitioner is that the said representation has not yet been considered by the respondents despite a long lapse of time. A representation in the form of a letter would not suffice for the purpose of issuance of the record of rights, a computerized record of rights, a property register card.
Property register, form number 3.
Computerized property register card. In that view of the matter, reserving liberty to the petitioner to file necessary application in the applicable form accompanied by necessary documents, the petition stands disposed, directing the respondents to consider the said application as and when filed within a period of 30 days of such filing.
30 days.
It is good. Computer admitted records. 30 days is enough.
2 months I
admitted records.
30 days irodu.
37 Sabil Ahmed.
This is also the same writ petition with respect to some other town panchayat, Milord. Respondent number 5 has to consider, Milords.
Yaru?
Milords, the notice has to go, Milords. Standing illa.
Notice ಏನಕ್ಕೆ ಹೋಗ್ಬೇಕು?
Town municipal council ಯಾರು?
ಜಿಲ್ಲಾ
ಪಂಚಾಯತ್ ಕಿತ್ತೂರ್.
ಕಿತ್ತೂರ್ ವಿ ಶಿವರಾಜ್ ಹಿರೇಮಠ ಬರ್ತಾರೆ.
ಲಿಸ್ಟ್ ನೋಡಿ ಬರ್ಬೇಕು ಸಬೀಲ್.
ಕಿತ್ತೂರ್ ವಿ ಶಿವರಾಜ್ ಹಿರೇಮಠ.
And AG accepts notice for respondent number 1 and 2. Belgavi? Shivraj Hiremat accepts notice for respondent number 3 to 5. Petitioner is before this court seeking for the following reliefs.
Please.
Claims to be the owner of land in plot number 236, block P, New Kadroli village.
Not that is the earlier plot, Milord. It is subsequent plot is Milord's annex property number 568A5.
568/A/5. Situated at Kadroli village. ಇದರಲ್ಲಿ ಏನು ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ದು?
ಇದರಲ್ಲಿ ಸೇಮ್ Milord.
Computerized record of rights and
permission to construct the house, my lords.
First idu barbeකಲ್ಲ ಆಮೇಲೆ construction. Computerized record of rights. And grant him a license to construct the house over the said property. Wide, a representation had also been submitted on 4/11/23 at Annexure M, followed by further representation on 18/10/24 and 19/10/24 at Annexure N and N2. Insofar as the issuance of computerized record of rights, the respondents or respondent number 5 ought to have considered the same and issued the said computerized record of rights on the basis of the representation submitted by the petitioner. Insofar as the license to construct a house is concerned, it is for the petitioner to file necessary application in the proper format, accompanied by necessary documents for grant of plan sanction and building license. Hence, a mere representation in relation thereto cannot be considered. As such, I pass the following order. Petition is partly allowed. Respondent number 5 is directed to consider the representation at Annexure M, N and N2 above insofar as issuance of a computerized record of rights is concerned, and issue the same within 30 days of the date of receipt of a copy of this order. As and when the petitioner were to make an application for grant of plan sanction and building license in the applicable format accompanied by necessary documents, the same to be considered by respondent number 5 within a period of 60 days of such submission.
Bless your lordship, grateful.
38, Chikadkatti.
The defendant number 1, my lord, in the suit, my lord, has filed an IA, my lord, under our 26 rule, my lord. Suit for a declaration filed by the respondent number 1 herein. Lord, after completion of the evidence about, my lord, there are certain disputes with regard to the existence of, my lord, some ultras, my lord. The defendant number 1, my lord, has stated that there are 2 ultras and mud. Old, it is existing in the suit property that has been denied by the plaintiff. The plaintiff, my lord, claiming that he is the owner of the property, and he inducted defendants 2 to 6 as the possession as a permissive possession, and the defendant 2 to 6, my lord, instigated the plaintiff to set up the suit, my lord. Therefore, my lord, we made an application to ascertain what exactly the possession in the
ಏನು ascertain ಮಾಡಬೇಕು?
ಅಲ್ಲಿ, my lord, there are 2 gaddiges in the suit property. 2 suit gaddige, my lord, that is old, my lord, the ultras, that is, my lord, Swamiji's, that is 2. The plaintiff claiming that it is the only one. There are certain trees and there is a dispute with regard to the measurement of the houses.
How is that relevant for declaration of title?
Declaration of title is concerned, my lord, they have no any documents. But factually they are disputing.
Suit is for declaration of
declaration.
title. You are denying their title.
Yes.
How is the existence of a gaddige relevant for the purpose of determining the title?
That is, my lord, I am not, my lord, asking, my lord, to ascertain the title of the plaintiff or defendant. They have to be decided by the title based on the documents. Based on the documents.
Existence of tomb or otherwise is irrelevant for the purpose of consideration of the suit.
After, my lord,
is before this court seeking for the following reliefs. Notice to the respondents is dispensed with in view of the proposed order to be passed. The respondent number 1 had filed a suit in OS number 152 of 2011 seeking for declaration of the plaintiff to be the absolute owner of the suit property and restrain the defendant number 1 or anyone else claiming through him from interfering with the possession of the property. Pleadings have been completed, evidence of the plaintiff being led when the matter was posted for the evidence of defendant number 1. Defendant number 1 filed an application in order 26 rule 9 of the Code of Civil Procedure for appointment of a commissioner to inspect the property and submit a report as regard the status of the property and the existence of tombs therein. The said application having been opposed by the plaintiff came to be rejected while order dated 22/11/2022. It is challenging the same. The petitioner is before this court. The submission of Sri S.G. Kadarkatti, learned counsel for the petitioner, is that the status of the property and the nature of the property is required to be ascertained in order to properly and effectively decide the suit. And as such, the trial court has committed an error in rejecting the application filed for appointment of a commissioner by the petitioner. Having perused the plaint and the application filed by the petitioner, as also the impugned order, and the considered opinion that the suit being one for declaration of title, the said title being disputed by the petitioner defendant number 1, the existence of a tomb thereon or the nature of the property is irrelevant or immaterial for the purpose of deciding the title of the property. The second relief which has been sought for being a permanent injunction restraining defendant number 1 from interfering with the possession of the property. For that purpose also, the existence of tombs or otherwise would not be relevant. Hence, being of the considered opinion that the application has been filed at the stage of defendant evidence is only to protract the proceedings. I do not find any merit in the above petition. The petition stands.
There is no, after evidence, not before evidence. After completion of evidence.
Defendant number 1 evidence.
Adu earlier, my lord. That application filed earlier. Subsequent application after completion of evidence.
After completion of defendant evidence is only to protract the proceedings.
39, Ramachandra Mali.
Petitioner, my lords, seeking mandamus, my lords. Annexure B. For my lords, a reconciliation of seats from aided to unaided, my lords. As my lords, from 2014 to till today, my lords, the government has
already.
Notice is ordered, my lords.
Last time it was listed on 10/1/2020. Yes.
What are the instructions?
Lord, as per the instructions, in spite of several requests having been made to the institution, they have failed to submit necessary documents. And we have sent mail recently also to furnish necessary informations and documents to insofar as shifting and to fill up the vacant post. They are not cooperating.
Lords, next week, within 1 week, my lords.
We are agreed to with regarding to whatever, but unless and until he furnishes the documents, my lord, we cannot.
The petitioner is before this court seeking for the following reliefs. Learned AG on inquiry and instruction submits that though the respondent number 3,
Commissioner, my lord,
2,
yes,
is ready and agreeable to consider the proposal dated 39/2023 submitted by the petitioners at Annexure B. The said proposal is not accompanied by necessary documents.
Yes.
And as such, respondent number 2 has been unable to consider the said proposal. If that be so, it is for the petitioners to furnish the necessary documents or for the respondent to reject the proposal on the ground of the document not being published.
Please.
With the above observation, the needless to say, if the petitioner were to furnish the documents within 15 days from today, that is on or before 7th February, respondent number 2 shall consider the said documents and pass necessary orders by 7th March 2025.
Please.
40, SS Niranjan.
Defendant's petition, my lordship. Respondent filed a suit for partition and separate possession. After that, my lordship, petitioner filed a WS along with contract claim. And in the WS, my lordship, stated contention that one of the properties purchased by her by typographically error in the contract claim, my lordship, the same number was inserted. After that, my lordship, she filed a application for amendment of contract claim to delete that survey number because it is a self-acquired property of her. In that, my lordship, she stated that prayer that claiming 1/4 share. The court was rejected that application, my lordship.
Admission
They by typographical error earlier in the,
error property details ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ?
ಅಲ್ಲ, in the,
ಪ್ರಾಪರ್ಟಿ ಚೇಂಜ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಟೈಪೋಗ್ರಫಿಕ್ ಎರರ್.
in the WS my lordship, para number 17, C was clearly stated that my lordship, it is a self-acquired property of her. By oversight, my lordship, the cut and paste, my lordship, in the cut and paste, it is mentioned that the continuation.
Para 17 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
My lordship, in the WS.
ನಿಜ ಸಂಗತಿ. ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ಸ್ ಎಲ್ಲಿದೆ?
The property number was not mentioned, my lordship, schedule A. That is mentioned, my lordship. That is self-acquired property by herself.
ಮತ್ತು 1D ಆಸ್ತಿಯನ್ನು ಖರೀದಿಪಡಿಸಿದ ಸದನದ
The plaint
A and 1B.
1D, my lord. 1D of the plaint, my
1A
lordship.
and 1D. ಆಮೇಲೆ
That is
of
page
the
number,
plaint.
page number 12, my lordship, running page number 12 in the plaint, my lordship. The open site situated at Adhyapak Nagar, so and so, RS number 167/C2/2, plot number 30.
Is purchased by you.
Page number 24 in the counterclaim, my lordship.
Notice to respondent returnable by 5th March. The further proceeding in OS number 86 of 2020 pending on the file of the additional senior civil judge and JMFC Gadag is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 27th and an acknowledgement of service of notice on the counsel appearing for the respondent before the trial court to be filed on or before 4th February 2025. Failing either of which, the interim order passed would stand automatically vacated.
41 Mallikarjun Swamy.
So the copy on the council, PV Kerur.
R2 yaru? Your
Myself, madam.
Shri BV Kerur.
Please, madam.
Accepts notice for respond number 2. Registry is direct, print his name as such. Enidu?
Property tax, petitioner educational institution is.
Same education da?
Yes. Municipality.
I seek 2 weeks time to file.
If you have any commercial property, we'll reserve liberty. Nenne yav matter adu?
I'll give them.
Nenne neeve madidru.
I'll seek the instructions, my lord. Tax matter.
No, exclusively for education purpose. You ask Park.
Number. Number. Film 12.
12. Only used for bank and hostel purposes. Some of the properties are used for other commercial purposes. In fact. Hello.
42 Mallikarjun Swamy.
The acquisition of the land is called in
MC,
question.
Notifications, sir.
Yes.
42, my lords.
Accepting the real estate in support of IA 1 of 2025. The production of originals of Annex A, B and C being the notifications for acquisition is dispensed with.
It's the other matters.
A accepts notice for respond number 1.
For respond number 5, accept notice.
KDBR.
KDB.
Shashank Hegde has filed wakala. K8, my lord.
K8 was filed by Shashank. It has not been put up.
K8 has been filed by?
Shashank Hegde.
Shashank Hegde.
Shashank Hegde is directed to accept notice for respond number 2 to 4. Shri KL Patil accepts notice for respond number 5.
5, my lords.
Inna on yavdu?
Connected matters were listed before the other bench because Viresh Budhal had appeared in that matters. By special orders, it had gone to court all 6.
Idunu
So
connect madalle.
I should bring to a lordship's notice.
Connect with WP number?
10536020.
Birth code. ಯಾವತ್ತಿದೆ ಅದು ಡೇಟ್?
ನಾಳೆಗಿದೆ.
Release tomorrow.
25-1. 43 MM Patil.
suit for partition and separate possession, my lord,
Yes.
filed by the respondents, my lord.
Hmm.
There is no relationship between the plaintiff family and defendant's family, my lord. Earlier to this, my lord, they have filed an application for DNA test, my lord. That was allowed by the Honorable Trial Court, my lord. That was challenged before this Honorable Court. This Honorable Court allowed and set aside the order, my lord. Thereafter, they have approached the Honorable Supreme Court. Supreme Court reversed the order, my lord, and permitted, my lord. And thereafter, they have the director RFSL.
Trial court allowed the DNA testing.
Yes, ma'am.
High court.
Reversed the order, my lord. And they
Supreme
have
Court?
approached the Supreme
So
Court.
trial court order was confirmed.
Confirmed, my lord. And thereafter, my lord, the Annexure C, my lord, the RFSL director has written a letter to take a sample of blood of the petitioner mother and response mother, my lord.
So to give this sample
Yes, ma'am.
of mother.
Yes, ma'am.
Neevu,
Nano defense.
mother is who?
Mother is no more, my lord. She was died long back, 21 years back, my lord. And the trial court, my lord, on that day, my lord, I have filed a little bit objections, my lord, but without hearing to petitioner, my lord, passed the order, my lord. And in the earlier application, there was no prayer in respect of the plaintiff number 1, my lord.
Again, what is the order passed?
The annexure J, my lord, relevant page number 54, my lord. 54, my lord. In page number 54, my lord. In view of letter dated 12/12/2004 issued by the Deputy Director Official B, this case is advanced and taken on board. The counsel for the both sides are present. The Deputy Director made a letter stating that the opinion paternity of plaintiff number 2 and 5 defendants is kept pending for want of blood reference sample of plaintiff number 1 in order to rule out the possibility of common shared
Plaintiff
alliance.
number 1 yaro.
My lord.
Who is plaintiff number 1?
Mother, my lord.
Mother is dead antira, mother is alive antira.
In earlier application, IA number 18 ನಲ್ಲಿ ಸ್ವಾಮಿ ಅವರು 2 to 5 ಅಷ್ಟೇ ಇದನ್ನ ಮಾಡಿ application ಹಾಕಿದ್ರು. Now the director RFSL has written a letter seeking the blood sample of the mother of the plaintiff, that is plaintiff number 1, and mother of the defendants, my lord. But defendant's mother is died 21 years back, my lord.
Your plaintiff's mother is there, Allah.
Yes.
Let her sample be drawn.
Without, there is no pleading by the plaintiff.
There is a direction issued and the doctor idu beku andre kodಬೇಕು. Petitioner is before this court seeking for the following relief. In view of the proposed order to be passed, the notice to respondents is dispensed with. Respond number. The respondents had filed a suit in OS number 76 of 2013 seeking for partition and separate possession of the suit-stale properties. In the said suit, an application had been filed. In the said suit, the relationship being disputed, an application had been filed for carrying out a DNA test, which came to be allowed by a trial court on 2/6/2023 by allowing IA number 18. The same came to be challenged before this court when this court set aside the order of the trial court by its order dated 14 July 2023 in WP number 103578 of 2023. The matter having been taken up on appeal before the Honorable Apex Court, the appeal was allowed, and the Honorable Apex Court came to a categorical conclusion that the proposed DNA test is meant to facilitate the court to come to its conclusion with respect to paternity, and it is for the court ultimately to take a decision on this. And directed the DNA test to be carried out. In pursuance thereof, the blood samples of plaintiff number 2 to 5 And defendant number
1 to 3.
1 to 3 were drawn and sent to the forensic science laboratory. The Deputy Director, Regional Science Forensic Laboratory, Hubballi, vide its letter dated 12/12/24, wrote to the trial court seeking for the biological mother's reference sample so as to carry out the test in a proper manner. Considering the said request, the trial court, vide order dated 29/11/24, directed the samples of plaintiff number 1, 18/12/24, had directed sample of plaintiff number 1 to be drawn and forwarded to the FSL, RFSL. It is challenging the same the petitioner is before this court. The submission of Sri M. Patil and counsel for the petitioner, firstly, is that when the earlier application had been filed, the application was only as regards the carrying out of DNA test of plaintiff number 2 to 5 and defendant number 1 to 3, and there was no request made insofar as plaintiff number 1 is concerned, and therefore the present order passed by a trial court directing the furnishing of samples of plaintiff number 1 is not proper. Secondly, he submits that the Deputy Director of RFSL, having sought for the samples of the mothers of both the plaintiffs and defendants, the defendant's mother having expired 20 years ago, the same not being available, only the sample of the plaintiff number 1, being the mother of plaintiff number 2 to 5, could not be drawn. Having considered said, I have considered the objection, the contention of the counsel for the petitioner, and I have perused the orders. The trial court had initially directed the DNA test to be carried out to determine the paternity and whether the plaintiffs and defendants, so as to determine whether the plaintiffs and defendants are related to each other. This order has been upheld by the Honorable Apex Court, though this court had set aside the order of the trial court. The Honorable Apex Court has categorically held that carrying out of a DNA test will aid the determination of paternity and would assist the court in doing so. The request by the Deputy Director is only for furnishing a reference sample of the mother, the same being required to determine the paternity as per the Deputy Director. An expert having opined and requested for the DNA sample of the mother, I have the considered opinion that irrespective of whether the said sample was sought for in the application filed or not, the requirement of the sample of the mother's DNA is in aid of and in furtherance of the application which has been allowed by the Honorable Apex Court. A technical objection that there was no prayer sought for to draw the sample of plaintiff number 1 is not sustainable. Insofar as the second contention of Sri M. Patil and counsel for the petitioner that the mother of the defendants having expired long ago, the Deputy Director having sought for the samples of both the mothers of the plaintiff and defendant, only the sample of plaintiff number 1 cannot be drawn in the absence of a sample of the mother of defendants is also a hyper-technical one. Whatever is available today would be required to be furnished to the Deputy Director RFSL. It is for the RFSL to examine the same and submit a report, which will be considered by the trial court. The Deputy Director RFSL could also be informed about the mother of the defendants having expired long ago and the sample not being available, so as to enable the Deputy Director and the concerned scientific officer of RFSL to submit an appropriate report. Hence, I do not find any favor in the second objection submitted by Sri M. Patil. In that view of the matter, no grounds being made out, the petition stands dismissed. The Deputy Director, RFSL, is directed to comply with the order of the trial court at the earliest and submit a report.
44, Sikardkatti.
Plaintiff, my lord, before this court is the petitioner. My lord, the suit filed by the plaintiff for declaration to declare that, my lord, the suit way, my lord,
yes,
the plaintiff acquired the rights by virtue of, my lord, the mutation entry 533 of 1948, my lord.
Your application of commissioner is rejected.
My lord, then, my lord, both the parties have led an evidence, my lord. My lord, after, my lord, a completion of the arguments of the plaintiff's side, my lord, the defendants, my lord, almost took 19 adjournments for their arguments. Then, my lord, they filed an application surprisingly to inspect the
Commissioner.
spot.
For commissioner.
Well, commissioner, my lord, in this case, it is not arising, my lord, because I am not claiming, my lord, just, my lord, the road is formed or the pathway is existing, and, my lord, I am claiming a right. It was, my lord, 1948, the ancestors of the defendants have reported the matter to the revenue authorities, and mutation has been certified. Since then, my lord, the suit pathway is, my lord, existing. I am been using, my lord. Now, my lord, they destroy the way during pendency of the suit. An injunction was granted by violating the destroying, my lord, the suit pathway and dug the borewell. To show that, my lord, now they wanted to inspect the spot. That is not necessary. By virtue of, my lord, the mutation, I am entitled to declare.
Where is the mutation?
Please, my lord.
Where is the mutation?
Mutation, my lord, I have, my lord, in the plaint, it has been stated, para number, my lord, 4, my lord. ವಾದಿಯು ತನ್ನ ಜಮೀನು ರಿಜಿಸ್ಟರನ್ನು 182/1 ಎತ್ತು ಚಕ್ಕಡಿ ದನಕರು ತೆಗೆದುಕೊಂಡು ಬುರುಡಿ ಕಟ್ಟಿ ಹಿರೇಕೆರೂರು ರಸ್ತೆ ಅಂದರೆ XY ದಾರಿಗುಂಟ ಬಂದು NM ಸೇತುವೆ ಮೇಲೆ ಹಾದು MKJ ಏರಿಗುಂಟ ಬಂದು ಪ್ರತಿವಾದಿಯರ ಪೂರ್ವದ ಬದು JA ಗುಂಟ ಬಂದು ತನ್ನ ಹೊಲಕ್ಕೆ ಹೋಗಿ ಬಂದು ವಹಿವಾಟು ಮಾಡುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ಈ ಪ್ರಕಾರ ಸುಮಾರು 50-60 ವರ್ಷಗಳಿಂದ ವಾದಿ ಹಾಗೂ ಹಿರಿಯರು ಪ್ರತಿವಾದಿಯರ ಜಮೀನು ಪೂರ್ವದ ಬದುವಿನ ಗುಂಟ ಎತ್ತು ಚಕ್ಕಡಿ ಟ್ರ್ಯಾಕ್ಟರ್ ತೆಗೆದುಕೊಂಡು ಓಡುತ್ತಾ ಬಂದಿರುತ್ತಾರೆ. ಪ್ರತಿವಾದಿಯರ ಹಿರಿಯರಾದ ಚನ್ನಬಸಪ್ಪ ಸಿದ್ಲಿಂಗಪ್ಪ ದೊಡ್ಡಗೌಡ್ರು, ಸಿದ್ಲಿಂಗಪ್ಪ ದೊಡ್ಡಗೌಡ್ರು ಇವರು ವಾದಿ ಹಿರಿಯರಿಗೆ ರೀ ಸರ್ವೆ ನಂಬರ್ 182 ಹೋಗಲು ರೀ ಸರ್ವೆ ನಂಬರ್ 181/1 ಪೂರ್ವ ದಿಕ್ಕಿಗೆ 5 ಮುಳ ಅಗಲದ ದಾರಿ ಹಕ್ಕು ಕೊಟ್ಟಿದ್ದು, ಉಭಯತರು ಒಪ್ಪಿಗೆಯ ಮೇರೆಗೆ ನಂಬರ್ 535 ದಿನಾಂಕ 6/4/1948 ದಾವಾದ ದಾರಿಯ ಹಕ್ಕು ದಾಖಲಾಗಿದೆ. Based on this, my lord, he has been, my lord, they acquired the rights.
1948, you are seeking to enforce now.
Yes, my lord. Allah, enforcing not, my lord, there to declare. He acquired the rights.
Is it in existence now or not?
Yes, my lord, it is existing. They, my lord,
commissioner appointment ಮಾಡೋದು.
ಅಲ್ಲ
ಬೋರ್ವೆಲ್ ಒಂದ್ ಜಾಗದಲ್ಲಿ ಇದೆ, ಬಾಕಿ ರೋಡ್ ಇದ್ದೇ ಇರುತ್ತಲ್ಲ.
ಅಲ್ಲ there are no other roads, my lord, except this. There are no other roads, my lord. I have produced
That also will be determined by the commissioner and sub.
Commissioner, my lord, advocate commissioner cannot say all those things. It is now advocate has been appointed.
Advocate
Appointment, advocate
ಬೇಡ
ಮಾಡಿದೆ.
Then issue emergent notice to respond number 1 to 3, returnable by 20th February. The further proceeding in OS number 47 of 2014 pending on the file of the additional civil judge in JMFC Irekerur. He stayed till the next date of hearing. Process fee and copies by 27. Acknowledgement of service of notice on the counsel appearing for respondent before the trial court to be filed on or before 31st, failing which the interim order will stand automatically vacated.
Please.
45, P. Sidnanay Swami.
Hearing for the petitioner, my lord. The petitioners are the lordship judgment debtors, my lord. The respondent, my lord, filed a suit for recovery and declaration and recovery of possession, my lord. The suit came to be decreed with ex parte, my lord. The petitioners have appeared, your lordship, not filed a return statement. After that, your lordship, the respondent filed an execution petition EP number 13/2017, my lord. And in the said case, your lordship, notice has been served. After serving of the notice, my lord, the petitioners, your lordship, filed a civil miscellaneous number 5/2017, my lord. That is annexure B, my lord. In the said civil miscellaneous, my lord, the respondents have appeared. And when it comes for ending stage, my lord, the said civil miscellaneous came to be dismissed for non-prosecution, my lord. And thereafter, your lordship, the present respondents pursue the execution petition. And in the said petition, my lord, they filed a IA number 6 and 7 and 12, my lord. 6, your lordship, it is recovery of possession. And 7, your lordship, it is directed the court bailiff to vacate the position. And IA number 12, my lord, to give a police protection. 3 IAs came to be filed, my lord.
Yes.
And the Honorable Trial Court, my lord, allowed the IA number 6 and 7 and 12, my lord. Page number 103, my lord. And IA number 12 order is page number 116.
Directed to vacate the premises and give it. You
No,
can't
my lord,
object
it is
this.
exclusive
If you have
property.
put up any construction, the construction will also.
Yes,
go.
it 4 acres of land, your lordship, it is 65 for D, my lord. 67 for D. And your lordship, without notice, your lordship, they have conducted the survey. And based on that report, my lord, they made a false, they produced a false document before the court and obtained a decree, my lord.
You have to challenge it. You
Yes, I
this
challenge.
one.
Yes, I challenge my civil miscellaneous is pending, my
Dismiss
lord.
ಆಯ್ತು.
ಅದು DNP, it is when it is comes in ending stage, it is
miscellaneous
dismissed.
actually ಅದು
And
dismiss ಆಯ್ತು.
again, we filed a recalling of that order, my lord.
ಅದನ್ನು ಯಾಕೆ ಪ್ರಾಸಿಕ್ಯೂಟ್
ಅದನ್ನು ಪರ್ಸ್ಯೂ ಮಾಡಿದ್ವಿ, ಅದರಲ್ಲಿ ಡಿಲೇ ಇದೆ ಅಂತ ಅದು ಸ್ಟೇ ಕೊಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. And your lordship, kindly see page number.
Your
Page
counterpart
number
has not been
116.
diligent, Mr. Gnanaswamy.
ಇಲ್ಲ ಪೇಜ್ ನಂಬರ್ 116 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸ್ವಾಮಿ. Counsel for DHR filed so and so 151 heard argument for so and so and returnable by 3/2/2025. Now they are lots of precising this order. We are running business in the
Miscellaneous petition dismiss ಆಗಿದೆ. There is no.
ಇಲ್ಲ DNP ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅದೇ dismiss. DNP ಅಂದ್ರೆ dismiss ಅಲ್ಲ, allow ಅದು.
ಅದಕ್ಕೆ ರಿಕಾಲಿಂಗ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು.
Recalling
ಅಲ್ಲ
ಹಾಕಿ
ಸ್ವಾಮಿ,
ಕೂತ್ಕೊಳ್ಳಿ.
kindly see the order sheet of miscellaneous petition, my lord. If I am not pursued that your lordship miscellaneous, yes, my lordship may dismiss my petition.
You have not been diligent and you want to come in the way of the execution of a decree which has been passed against you on this frivolous
For
ground.
a moment only, my lord, kindly see.
Decree ತಗೊಂಡವನ್ಗೆ ಏನು ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ.
ಅಲ್ಲ ಇಲ್ಲಿ but
Court decree ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ.
it is adjusted land, my lord.
Petitioner is
They are
before
not
this
at all
court
in possession, my lord.
seeking. ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ ಪೊಸಿಷನ್ ಅಂತ.
ಅವ್ರಿಲ್ಲ ಸ್ವಾಮಿ possession.
ಯಾರಿಲ್ಲ?
The respondents ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವಿಲ್ಲ.
ನಾವು ಇದೀವಿ. We are running the business.
ನಿಮ್ಮಿಂದ ಪೊಸಿಷನ್ ತಗೊಂಡು ಕೊಡುವಂತ ಡಿಗ್ರಿ
We are running the business, my lord. Mud bricks.
That is the whole story.
ಅಲ್ಲ ಸ್ವಾಮಿ, kindly
Before
see
this
the
court seeking for the following reliefs. Notice to respondents is dispensed with in view of the proposed order to be passed. The respondents as decree holders had filed execution case number 13 of 2017 to implement the decree, to execute the decree passed in OS number 94 of 2013, by virtue of which the petitioners herein, the respondents herein were declared to be the owners of the land in survey number 67/3, and the defendants were directed to quit and deliver the vacant possession of the land measuring 20 guntas, more fully described in the suit schedule of the plaintiff within 60 days. The petitioner, though had appeared in the said suit, had not filed his written statement leading to the decree having been passed. On the filing of the execution petition, the petitioner had filed civil miscellaneous petition number 12 of 2013.
17. 5 of 2017.
5 of 2017.
Yes.
And Order 9, Rule 13 of the Code of Civil Procedure to set aside the ex parte decree. The said civil miscellaneous petition also came to be dismissed for non-prosecution. An application has been filed in civil miscellaneous number 12 of 2023 to recall the said order, which is pending. In the execution petition, in the meanwhile, in the execution petition, the bailiff was directed to inspect the property. IA 6 and 7 had been filed by the decree holder to direct the judgment debtors to deliver the possession, or in the alternative to direct the court bailiff to get the judgments vacated and hand over the suit land. The said applications came to be allowed by order dated 1/6/2024. The bailiff, being unable to vacate the judgment debtor on account of the opposition of the judgment debtor, had submitted a report in furtherance of which IA 12 was filed seeking for police protection, which also came to be allowed by order dated 8/1/2025. It is challenging all these three orders that the petitioner is before this court. A decree having been passed in the year 2016 is awaiting execution, though the execution petition had been filed in the year 2017. The petitioners who were defendants, though had entered appearance in the suit, had chosen not to contest the suit. Subsequently, a civil miscellaneous petition had been filed, which also came to be dismissed for non-prosecution. The conduct of the petitioners, both in the suit and in the execution petition, categorically indicates the delinquency on part of the petitioner to conduct the proceedings and/or their intention only to protract the proceedings. The decree having attained finality, I am the constitutional opinion that the orders passed on IA 5, 6, 7, and 12 are proper, there being a obstruction by the judgment debtors in handing over the possession. The execution court has rightly granted police protection. I do not find any infirmity in all the three orders. There being no grounds made out, the petition stands dismissed. IA 1.
Submission.
Three matter. Number 28. R. Nagendra Nayak.
Your Lordship, I'm appearing for the petitioner in this case. We're seeking for stay of Annexure Q, my Lordship, where the final voter list is declared. The question is that in the final voter list, my Lords, one Miss by name in 1931, Mankal Vaidya, Beena Mankal Vaidya's name has been declared. My Lordship, if you see at Annexure F, my Lords, at page 25. The opening.
Yes.
Yes, my Lords. Opening date, my Lords. It is. Can you find opening date at right side, my Lords, in the boxes?
Yes.
It is shown as 2/8/2024. And my Lords, again at Annexure G. Now these are the indications to show that her account has been manipulated just to put her in the voter list, my Lords. As per section 20 of 20 subclause 2 of 3 of Cooperative Societies Act, minimum 1 year she has to maintain to be eligible to become a voter list. Now, my Lords, if
What
you
is
see,
this statement? What account is this?
this is the opening of account in the bank, shareholder account in the Cooperative
How
Society
do we
bank.
make out from this? There's no bank name, there's nothing in this.
In the Annexure D, my Lords, Annexure D, page 23. There, my Lords, browsing shareholders. This is another indication where her name has again been shown as wife of Jattappa Nayak, whose account was fraudulently entered
This will
and shown.
require hearing, madam. We can't stop.
But,
All this one is fraud. We'll
yeah,
have to hear.
all the fraudulent manners. I've also produced
Not now, not now. The AGA accepts notice
some.
for respond number 1, 2, 3,
Well,
6.
but election is scheduled on 2nd Feb, my lords.
One submission.
4.
Private respondent I accept notice, my lord. There was a previous writ petition also. In that I myself had argued, my lord.
Accepts notice for respond number 5. Urban Cooperative Bank.
Notice ಆಗಬೇಕು. Election officer
Notice
Baramgoda.
to
That
respond
was
number
dismissed for premature, ma'am, because we had
3 and 4. Returnable by 19th February.
Please.
Election is on
29.
my lords, earlier date because the election is on 14th Feb, my lords.
If you want voting rights, we'll grant you. If you are going to stop somebody, no.
29 of petition, my lord, seeking contesting and voting rights, my lord.
Contesting illa.
Similar matters. Yes.
No contesting. And AGA accepts notice for respond number 1,
1, 2, and 4.
2 and 4. Election authority.
Election authority, Baramgoda.
So accepts notice for respond number 3, 5 ಗೆ
5 and 6 notice.
issue note. ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅವರು.
Issue notice to respond number 5 and 6 written by so and so. ಅದು cooperative society common order.
Please, public.
Voting only. 19 voting.
Kind.
Submission.
Seal number 47. I am told age is not there, my lord. They want to ask for time.
On behalf of learned age.
47.
On 29th, my lord.
47 at the request of learned AGA, relist on 29th.
Please.
With your lordship's kind permission.
Election matter, my lord. Tomorrow is the last day for nomination, kindly. Please, to the
Nomination.
Please.
Nomination, we are not going to interfere, only voting.
Kindly, no, nomination is not permitted, so that my lord, the nomination is not permitted, so that kindly.
Disqualified nomination.
No, my lord. The petitioner is working as a CRC and BRC in the private. Please.
Seal number 80, my lord.
Number 80, the B group. 80. We will take our chance, my lord, in the second half.
Unlikely to reach. Because there's a parted matter of that SCST that will take some time.
ಏನಂದ್ರೆ
Labor matter.
there is an interim order of stay
there is
till
urgency
the
in
next
there.
till today and probably
ಯಾವತ್ತು ಬೇಕು?
ಅಲ್ಲ ಅಂದ್ರೆ ಏನಾಗಿದೆ
ತೊಗೊಂಡಿದ್ರೆ wait ಮಾಡಿ.
no
Till number 62, your lordships.
Moment, madam.
in the meantime
62, a connected matter is there.
80 ಗೆ 62 connected.
ಇಲ್ಲ
No. Another, this is different submission.
there is a subsequent claim application made by the respondent. ಇಲ್ಲ I will make my submission.
Seal number 62, your lordships.
madam,
Connected matter is there. I'll furnish the connected matter to court officer. Any date may be given, your lordships.
62 connect to so and relist on 22 na. Relist on 13th February.
69. Much obliged.
Yes.
Next week candidate, our urban development authority change the lawyer.
At the request of counsel for the petitioner.
Interim order is there.
31st.
Interim order.
Interim order.
Sir, it's 2:30.
ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್. ಇಲ್ಲ ಇಲ್ಲ ಝೂಮ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೇವೆ.
ಇಲ್ಲ.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಇವಾಗ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್?
ಕೇಳಿಸ್ತಾ ಇದೆ.
Serial number
1.
List 4. And AG accepts notice for respondent number 1 and 2. Issue notice to respondent number 3 to 5. Returnable by 6th March. The operation and execution of the order dated 15/2/2023, bearing number so and so at annexure A passed by second respondent is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 27th, failing which the interim order will stand automatically vacated.
2 VP Vadvi.
In this matter, my lords, seeking permission, my lords, to write the exams, my lords. Tomorrow the exam is scheduled. For the shortage of attendance, my lords, now the petitioner is bearing 60%, 60.89% of the attendance, my lords. Now the required rate is 75%.
College is in Bangalore.
Please, my lords. KSLU, my lords.
Petitioner is Raichur address ಕೊಟ್ಟಿದ್ದ ಕಾಲೇಜ್ ಬೆಂಗಳೂರು
ಕಾಲೇಜ್ ಬೆಂಗಳೂರು.
ಅಲ್ಲಿ ತಾನೇ ಫೈಲ್ ಮಾಡೋದು ಬೆಂಗಳೂರಲ್ಲಿ ಇಲ್ಲಿ ಹೆಂಗ್ ಫೈಲ್ ಮಾಡಿ
ಅಂದ್ರೆ
ಎಷ್ಟಿದೆ ಅಟೆಂಡೆನ್ಸ್
60.89 my lords.
ಎಷ್ಟು ಬೇಕಾಗಿತ್ತು 65
75 my lords.
75
And the ground is that my lords, he was being amputated my lords. Right hand middle finger has been amputated because of some accident my lords. That I have annexed my lords, that certificate. And 5 days my lords, that came to be not being considered. At page number 15 my lords, annexure C.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಗೆ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ
ಅಲ್ಲಿ ಯಾರು I will serve my lords through hands.
ಬೆಂಗಳೂರಲ್ಲಿ ಹಾಕ್ಬೇಕಾಯ್ತ್ರಿ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಡ್ವೊಕೇಟ್ ಅವ್ರಿಗೆ
KSLU
KSLU ಅಲ್ಲೂ ಬರೀತಾರೆ.
The permitting authority is KSLU my lords. Even principal cannot do anything my lords, in this matter. As because tomorrow
exam has to happen in the college,
but hall ticket has to be issued by the KSLU.
How will enforce it ಗೊತ್ತಿಲ್ಲ ನೋಡಿ. If KL Patil accepts notice for respond number 1 to 3, please issue emergent notice to respond number 4, returnable by 25th February. The respond number 2 is directed to permit the petitioner to take up the remaining examination for the 5th semester of the 5-year LLB course at the 4th respondent institution for the academic year 2024-2025. Deals the shortage of attendance since it is contended that the petitioner was hospitalized, resulting in an amputation
middle
of one
finger
of his fingers, which was a cause for the petitioner not to be able to attend classes.
Please.
And delivery ordered.
Please, great.
The respondent shall act on a printout of the uploaded copy of this order, please, without insisting on a certified copy.
Please, great.
3.
In the meanwhile, office objections to be complied with.
Please.
3. Lingesh Kattemane.
Petitioner melody contesting the melody election melody.
Testing illa.
Melody in the petitioner is there is a no default of the melody in the no dues melody.
Testing kodala. Learned AGA accepts notice for respond number 1,
2
and 2
and 4 melody.
Notice to respond number 3 and 4, returnable by
4 also is government melody.
AGA for 1, 2 and 4. Issue notice to respond number 3, returnable by 4th March. Cooperative society.
But contesting vote.
No contest. Only vote.
Voting rights melody.
Only vote. Right.
4. Sharath Reddy.
My lords, I appear for the petitioner, my lords, in this matter.
Yes.
My lords, defendant number 1 and 2, my lords, they had filed a suit for partition and also for equal share, my lords. And they contended that bill dated 8/1/2002 made by my father to me shall be nullified, my lords, by the court, my lords. Now, my lords, I am challenging annexure A, my lords, that is order dated 21/2005, my lords, wherein they have filed an order 18 Rule 17 application to recall evidence, my lords. On 4/1/2024, my lords, they themselves have admitted that namdeno evidence illa, and because of their voluntary statement, my lords, the evidence was taken as nil. And later, my lords, I have cross-examined PW1, I have led my evidence also. Now,
You said you have no evidence.
I didn't say that.
That is what is recorded at para 3.
My lords,
Page 17.
my lords, it's not me who said who has no evidence. Defendant number 2 to 9, who collude, who have been transposed now, who are along with petitioner plaintiff number 1 and 2, said that there is no evidence, my lords. Because of which the evidence was taken as nil of defendant number 2 to 9, my lords. I am for defendant number 1, my lords. Petitioner is defendant number 1 in the matter, my lords.
You are impugning the order at page 16.
Yes, my lords.
This reads as if it is an application filed
by defendant number 2 to 5.
Ah.
I am for defendant number 1, my lords. Defendant number 2 to 5, they sail along with the plaintiffs, my lords. They're seeking for partition of the property by meets and bounds. And they dispute the registered will that is done by my father to me, my lords. Their application, my lords, is in page number 62, my lords, 61. And their affidavit is 62 and 63, where they themselves admit that, my lords. My lords, if I may read page number 63, my lords, affidavit.
Where is the order sheet for 24/1/24?
My lords, page number 9. Page number, it is not 24/1, my lords, it's 4/1.
Where is the order sheet?
My lords, it's 4/1/2023.
Illappa, order sheet illappa. How date is order sheet ತೋರಿಸಿ.
My lords, idralli order sheet produce madilla, but in the order dated 21/2020.
Everything depends on that.
My lords, in the order dated.
Produce it tomorrow. Take a printout from the website and produce it.
Yes, my lords.
That counsel for
My lords, the
petitioner
matter is taken up tomorrow itself, my lords, in the trial court. My lords, if I may permitted to read, my lords, in their affidavit.
Printout ತಗೊಂಡ್ ಬರ್ತೀರಾ? We want to see that. Without that order, we won't pass it.
Yes, my lords, I'll get the print.
Pass over.
'84, Sampat Kumar.
On behalf of petitioner, petitioner before this honorable court to quash the speaking. Yes. Today they have filing, my lord. Just now I received the objection. Just now they gave the objection.
You want to go through?
Madam,
ನೋಡಿದ್ದೀರಾ ನೋಡ್ಬೇಕಾ?
ನೋಡ್ಬೇಕು.
Counsel for respond number 1 has filed a statement of objection. Counsel for respond number 1 submit that you would be filing a statement of objection in the registry during the course of the day.
The last occasion, my lord, this honorable court had.
Argument ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ. Time ಕೇಳ್ಬಿಟ್ಟು ಮತ್ತೆ ಇದು
No,
ಒಂದೊಂದು
I just want to submit one thing. On the last occasion.
Fully submission.
Please, my lord. Last occasion, my lord, this honorable court passed an order stating that on or before 17/1, they have to file an objection. If they have not filed that, objection is taken as nil. I will go through the
office objection serial number 19 is still not allowed.
My lord, that is a
ಅದರ ಮೇಲೆ dismiss ಮಾಡ್ಬಿಡೋಣ.
My lord, please.
Counsel for respond number 1 submit that you would be filing a statement of objection during the course of the day. Copy thereof has already been served on the counsel for the petitioner. Counsel for the petitioner seeks for and is granted.
Monday, man.
Monday. It's time to go through the same and make a submission. Relist on 27th.
Please. Please.
List 1, B group matter, 46, Bahubali Kanvarti.
ಯಾರು ಪಿವಿ ಬಂದಿಲ್ಲ ಪ್ರಕಾಶ್ ಹುಡಿಕೇರಿ ಕಂಟೆಸ್ಟಿಂಗ್ ಅವರೇನಾ?
Yes.
It is listed for the first time after 2011. Last time it was listed on 24/2/2011. ಪ್ರಕಾಶ್ ಹುಡುಕೇರಿ ಇಲ್ಲೇ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾರಾ?
But regular ಆಗಿ ಬರೋದಿಲ್ಲ. He is not regular, but he is in trial court. ಅಲ್ಲ ಜಾಸ್ತಿ ಇಲ್ಲ ಬರೋದು ಕಡಿಮೆ.
ಅವರು ಇದು ಬಂದಿದ್ದೆ 2011 ಆಮೇಲೆ ಅವ್ರು ಚೇತನ್ ನಿಂಬಿಕಾಯಿ ಎಲ್ಲಿ ಚೇತನ್?
MS ಪಾಟೀಲ್
ಚೇತನ್ ಹೆಸರು ಪ್ರಿಂಟ್ ಮಾಡ್ಬಿಡೋದಾ? Registry is also direct to print the name of Sri Chetan El Nimbica is that appearing for respondent number 1. In order to provide an opportunity of respondent number 1 to be represented, relist on 5th February. ಅವ್ರಿಗೆ ಇಬ್ಬರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಬೇಡಿ.
Please. 47 Arjun, 48 Ravi Hegde.
ಪ್ರಶಾಂತ್
ನೋಡಿ
ಎಲ್ಲಿ? ಪ್ರಶಾಂತ್ ಉಸ್ಮನಿ.
Shant Usmani.
ರೀಸೇಲ್ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೋಡಿ.
ಇಲ್ಲ.
ಶಾರ್ಟ್ ಮ್ಯಾಟರ್ ಲಾರ್ಡ್.
ಶಾರ್ಟ್ ಲಾಂಗ್ ಇಬ್ರು ಇರಬೇಕು. Though counsel for the petitioner is present, none appears for the respondent. None were to appear for the
We'll
respondent.
inform my lord colleague. Ask him to inform.
ಬಂದ್ರ? ಪ್ರಶಾಂತ್
7 Shant Usmani.
Lord the
yes. ಹೇಳಿ.
award.
Am I audible, my lords?
You are audible. Are we audible?
Please, my lords. I have to respond.
We agree audible.
Lord, an employee of Respondent Corporation has been charge sheeted on 24/5/2012, Lord, alleging of unauthorized absence for the period from 26/3/2012 to 24/5/2012. From thereafter, Lord, after filing his defense, saying that he was unwell due to the accident which has happened while replacing the tire which was punctured while helping the driver. Then, my lord, inquiry was conducted, which resulted in an order of dismissal dated 15/5/2013, which led to an industrial dispute, my lord, before the labor court under section 10(4)(a) of the act. And, my lord, the parties have filed their pleadings. And labor court, my lord, framed three issues. Then, my lord, in answering the issues, the first issue was held to be affirmative in favor of the management with regard to the validity of domestic inquiry. Then, my lord, on merits, my lord, the workman got examined himself and he has stated reasons for his absence, which was beyond his control. Then, my lord, the learned judge, while answering the other issues, dismissed the petition filed by him, my lord, holding that the dismissal order passed on the allegation of absence for almost 3 months is justified and he is not entitled for any relief. During the interim, my lord, the workman got retired in 2022. In the similar circumstances, my lord, this court has toned down the punishment of dismissal into some other punishment, reinstatement with stoppage of 2 increments and 3 increments. Then, my lord, now reinstatement is, my lord, is not capable of being given to him. I would only request, my lord, the other benefits, treating him as if he is on duty, my lord, by
on duty ಹೆಂಗಾಗುತ್ತೆ?
notionally, my lord,
You
for
will not
other
give
benefits.
back wages normally if we have to reinstate.
Back wages, my lord,
Some lump sum we can direct.
yes, that also, my lord.
Yes, Mr. Osmani.
My lords, in this case, my lords, this particular
Where the medical documents as
that,
regards
my lords, may I request my lords to kindly see, my lords, para 13 of the labor court's order, wherein, my lords, as far as the medical
Lord,
evidence
the
that is produced
exhibit
by
13,
the workman has been
14 and
very
15.
succinctly, my lords, has been discussed.
Para
13 for a moment may kindly be seen, my lords. Page 37, my lords, para number 13.
as regards the medical certificates?
Para
Page
37. 37. The claimant has produced the medical certificate issued by Dr. So and so at exhibit. His claim statement or in his chief examination, he has not at all stated anything about he taking treatment with Dr. So and so. The authors of those two documents. Exhibit W7 and W15, it is stated that the claimant took treatment with these doctors for cervical spondylosis, whereas, my lords, he says he had some disc
issue. ಅಲ್ಲಿ ಹಿಪ್ ಅಂತ ಹೇಳಿದಿರ ಸರ್ವೈಕಲ್ ಸ್ಪಾಂಡಿಲೈಟಿಸ್ ಅಂತೀರ, ಸರ್ವೈಕಲ್ ಸ್ಪಾಂಡಿಲೈಟಿಸ್ ಅಂತ ಹೇಳಿದಿರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ.
ಎವಿಡೆನ್ಸ್ ಅಂಡ್ ಮಿಲೋಡ್
ರಿಪ್ ಗಾಟ್ ಇಂಜರ್ಡ್ ಅಂತಲ್ಲಿ ನೀವು ಪೆಟಿಷನ್ ಅಲ್ಲಿ.
ಎಸ್, ಅದು ಒಂದಿದೆ. ಇನ್ನೊಂದು ಮಿಲೋಡ್, ಹಿ ಆಲ್ಸೋ ಸ್ಟೇಟೆಡ್ ಹಿ ವಾಸ್ ಅನ್ವೆಲ್ ಫಾರ್.
Further, my lords, I'll read exhibit W1 and also the reply given by the charge sheet. The wheel pan of the tire suddenly came outside with the claimant along with duty driver while repairing the punctured tire, and while pan touched up to the left hip of the claimant, so pain started there, etc. If we peruse exhibit W7 and W15, nowhere in these certificates it is stated regarding any type of injury caused to the left hip of the claimant. The claimant has stated that he was also undergoing treatment at Belgaum Institute of Medical Science and Dr. So-and-so treated him and gave certificate. If we peruse exhibit W18, in this also there is no mention about the claimant taking treatment at BIMS Hospital on 26/3/2012 onwards. As in this case, charge sheet was also issued to the claimant alleging that he remained unauthorously absent for his duties from so-and-so. Then, my lord, this is regarding, my lords, his medical evidence. And this is not a solitary incident, my lords, wherein he has been, my lords, inquiry has been conducted. Prior to this, 19 such cases, my lords, on the charge of absenteeism. He has been, my lords, warned, minor punishment have been imposed. This is not, my lords, a solitary incident.
Your medical certificate don't support you, Mr. Hegde.
And
Lord, even still, my lord, my
the court has held that it is not a genuine certificate.
The reason assigned, kindly take, my lord, the cross-examination. Not even a, my lord, page, my lord, 22.
ನೀವು ಫಸ್ಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಬೇಕು ಏನಕ್ಕೆ ಬಂದಿಲ್ಲ ನೀವು ಅಂತ, that it was beyond your control and
ಆರಾಮ್ ಇರಲಿಲ್ಲ ಅಂತ. That's what his, my lord, his statement is, my lord, he was unwell. Therefore, my lord,
his statement is contradictory. He is saying spondylitis, he took treatment in BIMS. ಇಲ್ಲಿ ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ he took treatment in Nipani and Chikkodi.
These medical certificates,
ನಿಪಾಣಿಗೂ ಚಿಕ್ಕೋಡಿ ಹತ್ರ ಇದೆ, ಬಟ್ ಅಷ್ಟತ್ರನೂ ಇಲ್ಲ. If he can travel from Belgaum to Chikkodi to take treatment, he can attend his office also.
Yes,
and once to Nipani.
For treatment, my lord, he has taken, it is supported by the
He
medical
could have
document.
come and given a leave letter or something, he could have sent it. Not that he was immobile. The way that you have projected is that he was immobile. If idagide anta ಬರಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂತ, he is not immobile.
Even, my lord, in the cases where, my lord, the misconduct, there were no, my lord, plausible explanation. This court has toned down because of the allegations made, which doesn't warrant, my lord, the punishment of dismissal. Which doesn't.
If he had produced proper medical, this one, yes, we would have agreed with you. We were in agreement with you and we asked you the medical.
These medical certificates, my lord, in the cross-examination, there is not even an iota, there is not even a one question put.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದ್ರಿ ಅವರಲ್ಲ, ನೀವು ಒಳ್ಳೆ ಕಥೆ ನಿಮ್ದು.
It was produced even before the inquiry
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಂತ, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ರಾಂಗ್.
Before the inquiry officer.
ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು? Petitioner is before this court.
My lord, my humble submission is, my lord,
in some amount you will pay Mr. Osmani.
But not in this case, my lord, because he is a part of 19 such cases. We should not, my lords, incite others to.
Petitioner is before this court seeking for the following relief.
Lord, may I pass it on one judgment, my lord, where the punishment has been toned down.
We have toned down in so many matters, if the evidence is proper.
My lord, my humble submission is, even in the present case, the finding of even the inquiry officer and by the labor court is, my lord, he has willfully remained absent. My lord, that is not the reason assigned even by the inquiry officer. In the similar cases, my lord, this court has toned down the punishment where duration of absence is small.
Yes.
Para 8, my lord,
medical certificate was there.
Even such case also, my lord, in the case on hand, my lord, there is hardly a 3 months, they say, he remained absent.
Petitioner is before this court seeking for the following reliefs. The petitioner had been appointed as a conductor with the respondent corporation on 10/8/1990, alleging that the petitioner was absent from his duties without leave from 26/3/2012 to 24/5/2012.
Two months almost.
When was the notice issued?
Lord, the articles of charges
Show cause
were
notice ಯಾವಾಗ?
24/5/2012 is the
Disciplinary
articles of
proceedings were initiated against the petitioner. The articles of charge were framed on
24/5/2012.
24/5/2012. Inquiry being conducted. The inquiry report held the petitioner to be guilty of the misdemeanors alleged against the petitioner. The second show cause notice having been issued, after consideration of the same, ended in the dismissal of the petitioner. The petitioner challenged by the order of dismissal before the Labour Court Hubballi by filing KID number 52 of 2013 under section 10 bracket 4 hyphen capital A of the Industrial Disputes bracket Karnataka Amendment Act 1987. The Labour Court dismissed the said petition, that claim petition is agreed by same, the petitioner is before this court. Shri Ravi Hegde, learned counsel appearing for the petitioner, would submit that on 21/3/2012, when the petitioner was on night duty, as regards in vehicle number F353, the backside tire of the said bus was punctured, and as such, when the tire was being replaced, as such, since there was no one else, the conductor was helping the driver, and when the tire was being replaced, suddenly the wheel pan turned by and hit the left leg joint of the petitioner, and thereafter the petitioner took treatment from a local doctor, and thereafter approached the Belgaum Institute of Medical Sciences, where he was treated by an orthopedician, and due to the said injury, the petitioner could not attend to his duties from 26/3/2012. The absence of the petitioner is not wanton, but on account of medical injuries which had been suffered by the petitioner, which ought to have been taken into consideration firstly during the inquiry stage and secondly by a labor court, and the orders which have been passed of dismissal by the by disciplinary authority confirmed by labor court is required to be set aside. Shri Prashant Oshmani, learned counsel appearing for the Road Transport Corporation, by referring to the judgment of the labor court, more particularly para 13 thereof,
13.
submits that the claimants and they submit that the petitioner's contention are contradictory inasmuch as in the pleadings filed, in the claim petition filed, it was contended that the petitioner suffered from an injury to the left hip, which left him immobile, and he underwent treatment at BIMS Hospital from 26/3/2012 onwards. However, the evidence led was completely different inasmuch as it was contended that the petitioner underwent treatment by Dr. Renake, Renake, and Dr. Kavatigi Mutt at Nipani and Chikkodi respectively. And the documents at Exhibit W7 and W15, which had been produced by the workman, indicated that the treatment was for cervical spondylitis, which is contrary to the claim made by the workman of an injury to the left hip. He submits that the petitioner being required to report to Belgaum, the petitioner contending that the petitioner was being treated at the BIMS hospital but the medical certificates have been produced of doctors in Nippani and Chikkodi would indicate that the petitioner is not immobile and that the entire case of the petitioner was based on falsities. Therefore, in the absence of consideration of the medical excuse stroke justification made out by the workman, the absence of the petitioner would have to be regarded to be wanton, and as such the action taken by the disciplinary authority and confirmed by the labor court is proper and correct. Heard so and so produce papers. There is substance in the submission made by Sri Prashant Vasmani inasmuch as the contentions of the workmen are contradictory to each other. In the event of a workman being absent from duties without obtaining prior leave, it is but required for the workman to establish that his absence was not wanton and that the absence was necessitated on account of reasons beyond his control. If at all the petitioner had been able to establish the alleged hip injury by producing appropriate medical proof, the same would have been a ground to consider the contention of the workman. However, the contention of the workmen are being contradictory to each other. On the one hand, contending that because of injury to the hip, he could not attend, and on the other hand, producing documents that of doctors indicating that he was suffering from, he was being treated for cervical spondylitis, and they consider opinion that the said excuse, which has been excuse stroke justification offered by the workman, is not bona fide, and as such, the same cannot be accepted and has been rightly rejected by the labor court. However, taking into account the fact that the petitioner had been appointed in the year 1990 and had attained the age of superannuation on
Lord, on 26/7/2022.
26/7/2022, the dismissal having occurred on
Lord, 15/5/2013.
15/5/2013. I have the considered opinion that the absence for 60 days, as indicated above, would not necessitate the punishment to the extent of dismissal of the petitioner. In that view of the matter, I have the considered opinion that the grievance of the petitioner could be satisfied by directing the Road Transport Corporation to make payment of certain compensation on a lump sum basis. As such, I direct the corporation to make payment of a sum of rupees. Yes to Mr. Osmani?
My lords, in this case, my lord, since the workman has a history of 20 such cases, he may not be, my lords, entitled, because this should not, my lords, incite others also.
At least what is being
Having,
spent on litigation can be ಮಾಡ್ಬೋದು ಅಂತ ಅಷ್ಟೇ.
Any reasonable amount, my lords.
Sum of rupees 50,000 to be paid to the petitioner within 4 weeks from the date of receipt of a copy of this order.
Grateful.
49, 50, 51 Arjun, 52 Prakash Padige.
Mr. Bassareddy? ಯಾರು ಆನಂದ್ ಶೆಟ್ಟಿ? Who is
Malikarjun C.
Bassareddy
Bassareddy.
or Anand Shetty? APMC ಯಾರು?
Malikarjun C. Bassareddy.
ಅವರಲ್ಲಿ ಕಲಬುರಗಿಯಲ್ಲಿದ್ದಾರೆ.
Anand B. Shetty.
Mr. Anand Shetty? Though counsel for the petitioner is present and ready to address his arguments, none appears for the respondent. In order to provide an opportunity to the respondents to be represented, relist on 6th February. If none were to appear for respondent on that next date of hearing, the petition will be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Stay may be extended.
Interim order earlier granted is extended till next.
53 Rajesh Rajnad.
Kindly have a next week. See.
ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
Please.
At the request of counsel for the petitioner, relist on 7th February.
Please.
54 A.S. Patil, Sabil Ahmad.
Sabil. ಇದರಾ? None appears for both the parties to provide an opportunity for them to be represented. Relist on 31st January.
55 D.L.R. Khan.
My lord, I represent the petitioner in this case, my lord. A case of the petitioner is that an application under order 26 rule 9 came to be filed by the plaintiff in a suit for permanent injunction at the initial stage, wherein the plaintiff suffered an order, did not get any injunction order. Thereafter, the plaintiff got amended the plaint for a declaration and a permanent injunction. And now the plaintiff has filed an application for appointment of a court commissioner to measure and ascertain the encroachment of the area, my lord. The learned civil judge has passed an order delegating his powers to the commissioner to mark the property and declare it as an encroached area. That finds a place at page number 51, my lord. Operative portion of the order, my lord. IA number 14 filed by plaintiff under order 26 rule 9 read with section 151 of CPC is hereby allowed.
If you are not encroached, why are you worried, Mr. Lord Khan?
No, lord, my objection to the said application is that, my lord, I have constructed my property much long before the plaintiff could take up the suit. One aspect. Second, the plaintiff himself is not the owner of the property. That finds a place at Annexure B, my lord, a document produced by the plaintiff.
That will be decided by the court, but now as held by the coordinate bench of this court, in all matters relating to injunction and the like of encroachment, it's better to appoint a commissioner. Let the report come, because no amount of evidence can be led in a proper manner in this.
I have not placed judgment of this court, coordinate bench judgment in WP number 10826 before the court, my lord, wherein this court has held that seeking and delegating the power of the court to declare the area as an encroachment is contrary to law.
Declaring Allah to ascertain the status of the property.
in a way, the learned civil judge has delegated his power to the commissioner to identify and declare it as Agatha Swami. The city commissioner is hereby appointed as a court commissioner in order to make a spot panchanama of the plaintiff and defendant.
Not to declare, only to
property.
conduct
They
a
have
spot
identified the encroachment. I mean, thereby to identify the encroachment. A property measurement ಮಾಡಿ report ಹಾಕೋದು ಬೇರೆ ಆಗುತ್ತೆ. Now what
encroachment ಮಾಡಿದಿರೋ ಇಲ್ವೋ?
ಇಲ್ಲ ನಮ್ದು encroachment ಇಲ್ವೇ ಇಲ್ಲ. ಅವ್ರ ಪ್ರಕಾರನೇ as per the very version of the plaintiff, he is not the owner one service.
Then don't worry if you are not encroached. Petitioner is before this court seeking for the following reliefs. Respondent number 1 had filed a suit in OS number
165.
615 of 2012, initially seeking for a permanent injunction, which subsequently came to be amended for for declaration of title and recovery of possession.
Not declaration title.
In the said suit, an application in IA number 14 was filed under Order 26 Rule 9 of the Code of Civil Procedure, seeking for appointment of court commissioner to make a spot inspection and report on encroachment, if any, made by the defendants. The said application, though was opposed by the petitioner, defendant number 2 therein, came to be allowed by the impugned order dated 10/3. ಯಾವ date? 10/3 ಇದೆ, 25/2 ಇದೆ, ಯಾವ್ದು ಡೇಟ್ ಇದು? What is the date of the order, Mr. Latkan?
25/2/2020, my lord.
Your date
25/2, my lord.
25/2/2020. It is challenging the same. The petitioner is before this court. The submission of Sri D.L. Latkan, learned counsel for the petitioner, is that the trial court ought not to have allowed the application for appointment of a commissioner. By appointing the commissioner, the trial court has delegated its duties to the commissioner. It is for the trial court to have considered the evidence led by either of the parties and come to a conclusion if at all there is any encroachment, and then pass necessary orders. Shri Chidananda, learned counsel appearing for respondents, respondent number 1 would have contend that the trial court has rightly allowed the application in order to ascertain if there is any encroachment. No amount of evidence could be properly led in relation thereto. And in this regard, he relies upon the decision of a coordinate bench of this court.
ILR 23, Karnataka 3983.
In ILR 2023, Karnataka 3983, more particularly para
16, 17 and 21. Para 16 and 17 and 21, these are the
20 and 21, which are reproduced hereunder for easy reference. The coordinate bench of this court has come to a conclusion that whenever there is a dispute relating to boundaries or encroachment, a commissioner could be appointed by the court. In the present matter, the dispute is as regards the encroachment of the property of the plaintiff by the defendants. The commissioner would be necessarily inspecting the property, measuring the property, marking out the boundaries, and submitting a report in relation thereto. If at all the petitioner is not encroached upon the land of the respondent number 1, the petitioner has nothing to worry about. In that view of the matter, the order passed by a trial court being proper and correct and suffering from no infirmity, the above petition stands dismissed.
The one submission, my lord.
Yes.
defendant petitioners before this court may be permitted to file a memo of instructions to the commissioner to ascertain their boundaries, my lord.
The
Now the
High
plaintiff
Court
is before
having
this court.
permitted
Warrant
both
also
the
issued.
plaintiff and defendants to file their respective memo of instructions, the time granted is extended by a period of 1 week from today, with both the petitioner and the respondents herein being
ಅಲ್ಲ ವಾರೆಂಟ್
permitted,
ಇಶ್ಯೂ ಮಾಡ್ಯಾರ ಅವ್ರು.
memo kodi, being permitted to submit their respective memo of instructions.
2 weeks ಕೊಟ್ರೆ ಸ್ವಲ್ಪ ಅನುಕೂಲ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
2 weeks ಬೇಡ, 1 week ಸಾಕು.
ಅಲ್ಲ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಪ್ಷನ್ ಮಾಡಿ ಕಳಿಸಿ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಏನ್ ಬೇಡ.
Next
ಪ್ಲೀಸ್
next matter weeks time kindly because ಏನು 56
ನೀವೆಲ್ಲಿದ್ದೀರಾ ಅದ್ರಲ್ಲಿ?
ನಾನು ಕೆಳಗಿದ್ದೀನಿ ಹತ್ತಿ ಅವರು
ಇದೀರಾ
next week.
At the request of counsel for the petitioner.
I'm waiting for the responding.
ಯಾವಾಗ?
Any date?
Released
Any
on
date?
6th February.
Oblige. Please. Sorry.
57 ಮೃತ್ಯುಂಜಯ ಹೇಳಿಕೇರಿ.
My lord, petition number 1 is dead, my lord. I will file the LRS
Who is
application.
dead?
Petition number 1.
Uh,
So I will file the LRS application kindly,
Petitioner
short
submitted
accommodations.
petition number 1 is expired. She seeks for and is granted.
Channappa, yes, my lord, is urgent.
ಎಷ್ಟು ದಿನ ಬೇಕು? ಇಲ್ಲ ಅವ್ರ legal representative ಇದಾರೆ already record ಅಲ್ಲಿ.
No, my lord, legal is.
Seeks for and is granted 2
Short
weeks time to file necessary application to bring the legal representatives of deceased petition number 1 on record. Released on 17th February.
58 Jay Shetty.
Malad, I am appearing for the petitioner. In fact,
Submission may call for records. Land tribunal.
moved by the other side, Malad, in fact.
The records that is directed to secure the records. Released on 20th February.
Interim order, make
Interim order earlier granted is extended till next day.
59 Chetan Munnoli. Chetan Munnoli.
None appears for the petitioner. A week's time is granted to the petitioner to be represented in the matter. Released on 31st January.
60 Naveen Chitrat.
This case, I am applying for petitioner 6 week after next. I intimate respond conference.
The request of counsel for the petitioner released on 6th February.
61 Venkatesh Kharvi.
You will see interim order make extended.
Interim order 60.
Petition for order 18 rule 17 was rejected by the trial court.
18 rule 17 at what stage?
On the ground that, my lords, now is argument, my lords. Arguments.
Argument ಆಗೋಗಿತ್ತು.
ಅಲ್ಲಲ್ಲ
ಆಗೋಗಿದೆ.
For defendant's arguments was over. At that stage, my lord, he wanted to.
He called for what purpose?
On this, my lords, that is a suit for specific relief of contact, my lords. Subsequently, my lords, that suit was only the defendant appeared on 2010. He has filed just on written statement and he did not appear. Suit came, my lord, just 1 minute. Suit came to decree. Subsequently, my lords, he filed a first appeal before this honorable court on 2012. That was remand order on 21. On meantime, my lords, whatever, my lords, the defendant respondent number 1, he is a bank employee. She taken the loan. She know the consequence of the case, my lords. She can 10 lakh rupees loan from the bank, my lords, though she know the decree in favor of the plaintiff. So the remand was, RF was remanded by costing rupees 50,000, my lords. So thereafter, my lord, he cross-examined 2022, he cross-examined the plaintiff. 2022, he cross-examined the plaintiff. Subsequently, he, that is defendant as came to the witness box and he also cross-examined. Then we came to know that, my lords, we have purchased we have sold the land to the airport Hubli on 2009 and 9. That amount was deposited in the KVG bank. That document was not produced before the court, but through oversight, because we had change of the house, my lords, we have misplaced the documents.
So the land subject matter of the agreement is acquired.
Yes, sir. We are in possession. We are in possession. We have
Who is in possession?
paid, my lord, 80% of the amount, that is totally 22,20,000. I am for the plaintiff, my lord.
ಅಲ್ಲ acquisition ಎಲ್ಲ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ಏರ್ಪೋರ್ಟ್ ಆಗಿ ಅಲ್ಲಿ ನಾವು ಮಾರಾಟ ಮಾಡಿ ಆ ಅಮೌಂಟ್ ಅನ್ನ ಕೆವಿಜಿ
ಅಕ್ವಿಸಿಷನ್ ಆಯ್ತಾ ಮಾರಾಟ ಮಾಡಿದ್ರ
ಮಾರಾಟ ಮಾಡಿದ್ವಿ.
ಯಾರಿಗೆ?
ಬೇರೆಯವ್ರಿಗೆ ಮಾಡಿದೆ, ಇವ್ರಿಗೆ ಮಾರ್ವಾಡಿಗಳಿಗೆ.
ಮತ್ತೆ ಏರ್ಪೋರ್ಟ್ ಅಂತ ಇದ್ದೀರಿ,
ಅಲ್ಲಿ ಏರ್ಪೋರ್ಟ್ ಹತ್ರ ನಮ್ದು ಜಾಗ ಇತ್ತು, ಅದನ್ನ ನಾನು ಮಾರಾಟ
ವ್ಯಾಲ್ಯೂ
ಮಾಡಿದ್ವಿ.
ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತ ಮಾರಾಟ
ಅಲ್ಲ ಮಾರಾಟವಲ್ಲ, ದಟ್ ಈಸ್ ಎಕ್ಸಿಬಿಟ್ P12 to 22 that was examined. ಆ ಅಮೌಂಟ್ ಅನ್ನ ನಾವು KVG ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ, ದಟ್ ಈಸ್ ಆನ್ ರೆಕಾರ್ಡ್. On that document, so I have not produced before the court, trial court. On that ground,
evidence is required to be laid for that. Why is that evidence?
because my lords, they have said they have not capacity in the cross examinations that to purchase the property. So as per the sale deed, my lord, exhibit P12 to P22, my lords, I have produced the sale deed also, that we have amount to purchase the property, and also the one CD that I have produced, my lords, the conversation between the dependent number 1 and the plaintiff son, that ನೀವು ಹೆಂಗ್ ತಗೊಳ್ತೀರಿ ಅಂತ, ನಾವು ಕಬ್ಜಾ ಇದ್ರು ಇರ್ಲಿ, ನೀವು ಹೆಂಗ್ ತಗೊಳ್ತೀರಿ, that was CD.
You were supposed to do it before.
No. It is what only one document I have permission granted by this honorable court only to produce in respect of that transaction, that is the suit for specifically. The trial court is, my lord, relied upon on the judgment of the Ramarati, my lord, that is the omission on fill up the lacuna, then the application under order 1817 rule is not applicable. On that ground it was returned, and he has not showed the reason in the impugned order, my lord. That is only, my lords, my contention as per the judgment passed by this honorable court in corner bench, my lords.
When did you sell that property?
I have sold the person 2007 and 8, my lords.
What is it?
And agreement is 2009, my lords. Agreement is 2009. And there is a supplementary 3 agreement on 1/9/2009, my lords. And there is a supplementary agreement on 9/4/2020, 10 and 24/6/2010. We have paid the, my lord, out of 22 lakh, 20 lakh we have paid.
Where is the pleading in your plaint about that?
Yes, that is in the plaint, my lord, para number, my lords.
Really the pleading?
In para number 7, my lords. In page number 14. 7 and 8 para numbers.
Now, where is it that you have said that you had the monies and it is because of this you had the money anta?
1 minute.
In pleading idre iವಾಗ document produce ಮಾಡಕ್ ಬಿಡ್ಬೋದು. Pleading ಇಲ್ಲ ಅಂದ್ರೆ how do we allow you?
But even in the applications filed, there is no reason assigned.
Pleading ilvalla, Mr. Karvi. There is no pleading.
1 minute.
In paragraph 8, my lord, on paragraph 8 of the impugned order, it says, my lord, that even after arguments of both plaintiffs and defendants already concluded, my lord, now whatever I have argued, he wants to cure, my lord, by way of an application, recall with
Some pleading we could have, there's no pleading.
and then, my lord, again I will do it and this will go on. The Supreme Court, my lord,
My
says
lord, it
that
is suit for specific relief of contract, my lord. That is,
You
my
have to
lord,
be
I have to.
diligent, Mr. Karvi.
Please, my lords, that
to be
is in
diligent.
stated in, my lord, para number 3, that was not forthcoming, my lords. Only that through him, the defendant offered to sell
There
suit
is no
property
avowment.
for legal necessities. And at that time, is during year 2009, plaintiff thought, para number 3, my lord.
Thought of purchasing ಅಷ್ಟೇ. ಈ
ಅದೇ
thought ಅಲ್ಲೇ
purchase
ಇದ್ಬಿಡ್ತು.
ಅಂತ ಮಾಡಿದ್ದೆ. But ಏನ್, my
Acted
lords?
ready and willing.
But as per the sale deed I have produced, my lord, that is exhibit P12 and P22. So all the sale deed I have produced, the property situated in 2007 and 8, my lord, in the month of, in the year of 2008. That I have produced, my lord, in page number, my lords.
Not at this stage. Petitioner is before this court
My lords.
seeking for the following reliefs. The petitioner is aggrieved by the dismissal of an application of 2 applications filed by the petitioner in IA number 13 and 14.
and 15.
And 15, my lord, 3
The
IS,
application, IA
13,
13
14
to
and
15,
15.
filed under order 18 rule 17, section 151 and 7 rule 14 of the Code of Civil Procedure. The said application had been filed seeking for permission of the court to produce certain documents and a CD and for recalling the plaintiff for further chief examination. The said application came to be rejected by the impugned order on the ground that the arguments of both the counsels had already been heard and that the application was filed in a belated stage. And secondly, on the ground that the application had been filed to fill up the lacunae pointed out by the defendant during the cross-examination of the plaintiff witness, as also during the course of arguments. It is challenging the same that the petitioner is before this court. The suit is of the year 2012. Initially, the suit came to be decreed on 21st September 2017. On an appeal being filed, the decree was set aside and the matter remitted to trial court vide order dated 4 September 21 in RFA number 100394 of 2017. This court had at the time of remand directed the trial court to provide an opportunity to cross-examine the plaintiff witness and lead defend evidence to the appellant in the said appeal. It is in pursuance thereof that the matter was taken up by the trial court, evidence was led and arguments were advanced by both the parties, and it is at that stage that the aforesaid applications had been filed. The burden of proof of proving readiness and willingness is always that of the plaintiff. The submission of Shri Venkatesh Karvi that the document now produced is required to establish that the plaintiff has the money to make payment of the sale consideration cannot be accepted at this stage when the matter is posted for arguments. The plaintiff had enough and sufficient time from the time of filing of the suit till now to have produced those documents, since it is the burden of the plaintiff to prove readiness and willingness which is required to be discharged. After arguments being heard, after evidence being completed and arguments being heard, if the defendant has taken up the contention of the plaintiff not being able to prove readiness and willingness and not having the amounts required to make payment of the sale consideration, at the belated stage after arguments are completed, the plaintiff cannot seek to bring any new document on record, thereby rendering the defense taken by the defendants negatory by filling up the lacuna pointed out by the defendants. In that view of the matter, I do not find any infirmity in the order passed by a trial court. The petition stands dismissed.
Please.
ಬಂದಿದ್ದಾರಾ?
ಮೇಡಮ್ ಜೂಮಿಗೆ ಕನೆಕ್ಟ್ ಆಗಿ ಮೇಡಮ್, ಜೂಮ್
mentioned, my
So
lord.
if you're working CRC and BRC, you can't contest the election.
Please, please.
Yes.
Now, my lord, we can't, we challenging this condition. Before this honorable court, and the honorable court is already stayed in some case, very Annexure B. And direct copy ಕೊಟ್ಟಿದೆ sir. Permitted to contest in Bangalore branch, my lord. Sorry, my lord, Bangalore court.
You want to contest for what election?
My lord, there is a teachers society. ಸಿಗ್ಗಾಂವ್ ತಾಲೂಕಾ ಪ್ರಾಥಮಿಕ ಶಿಕ್ಷಣ ಶಿಕ್ಷಕ ಮತ್ತು ಶಿಕ್ಷಕಿಯರ ಪತ್ತಿನ ಸಹಕಾರಿ ಸಂಘ ಪ್ಲಸ್ ಸಿಗ್ಗಾಂವ್ ಬ್ಯಾಂಕ್ ಎಲೆಕ್ಷನ್ ಇಸ್ ಗೋಯಿಂಗ್ ಆನ್ ಅಂಡ್ ಪ್ರೊಡ್ಯೂಸ್
ಏನ್ ಸೊಸೈಟಿ?
My lord, teacher society, teachers ಪತ್ತಿನ ಸಹಕಾರಿ ಸಂಘ.
Employees society.
Please. Government primary teachers.
There's a coordinate bench order.
Please.
Lord AGA accepts notice for respond number 1 to 3. In view of the order dated 15th October 2024 passed by a coordinate bench of this court in WP number 27693 of 2024. Till the next date of hearing, the condition imposed on the notification dated 16/12/2023 issued by respond number 2, prohibiting the petitioner from contesting election to the Employees Association is stayed insofar as it relates to the petitioner. Petitioner is consequently permitted to file nomination for contesting to the post of office bearer of the said association in the ensuing election, scheduled to be held on 28/10,
Please.
2024, subject to the outcome of the petition. And delivery order, your
Please.
nomination.
Please, please, my lord.
And delivery order.
Please. Much obliged.
Yes.
Last time leave.
ಯಾವ ತಕಣ?
Serial number 80, my lord. There is an interim order of stay granted in my favor insofar as the writ petition is concerned.
When do you want it?
ಇನ್ನೊಂದು ಏನಾಗಿದೆ, now what has happened is they have filed one more application with regard to which I filed an application for amendment. My lord was pleased to allow that application. The proceeding, the officer has closed the proceeding saying he will pass orders.
When do you want it, Mr. Anand?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ಸ್ಟೇ ಬೇಕಾಗಿದೆ ಸ್ವಾಮಿ, about which I have also made a prayer in the amended writ petition.
In this 80?
Please.
The matter was in fact known in the last occasion, it was argued.
My lord will
And
kindly
it is
see.
to be disposed of today, it is fixed, my lords. Because of the first of time, now it is being
In the
adjourned.
amended writ petition.
Subsequent period, we have made an application.
ನಾಳೆ ಇದೀರಾ?
Tomorrow, my
I'm
lord,
willing, ma'am. I'm willing.
80 release tomorrow.
may I request, my lord, at 2:30 minutes so that it will
2:30.
much obliged, much obliged,
Anytime.
80 release tomorrow at 2:30.
much obliged.
Obliged.
Your lordship, serial number 68 and 72, some urgency, it may be
ಏನು
tomorrow.
ಎಲ್ಲ urgency
Urgency
ನಿಮ್ಗೆ?
is your lordship, wherein your lordship, in the FDP, your lordship, we have filed impleading application. They have filed suit for partition. We have purchased property in the 2005 itself. Both the suits are clubbed, your lordship has stayed the matter. All the suits, 7 suits are stayed, your lordship. Adhike. Please,
Any date.
please.
68, stay may be extended.
67, my lord. Kindly, short time.
ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ.
Stay may be extended. 68, serial number 68. Please.
Lord, 83, this is a matter where it pertains to election is start. On the ground that, my lord, the deputy commissioner issued the notification. Admittedly, my lord, deputy commissioner has no jurisdiction to issue the notification. So, the government will issue the
83 release tomorrow.
Please.
Monday, my lord. Monday.
ನೀವು ಅರ್ಜೆಂಟ್ ಅಂದ್ರೆ ನಾಳೆ
ಇಲ್ಲ, Monday. Tomorrow I have some personal inconvenience.
Saturday released on Monday 27.
Please.
Sir. Sir, serial number 74.
ಸೀರಿಯಲ್ ನಂಬರ್
ಅದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀರಿ ಇಂಟ್ರಿ ಮಾಡಲ್ ಎಲ್ಲಿದೆ
ಮಂಡೇ ಅಷ್ಟೇ ಮಂಡೇ ಬೇಕಾಗಿತ್ತು 74 ಮಂಡೇಸ್ 27th
29 ಕೊಟ್ಟಿರ್ತೀನಿ ಮೇಡಮ್.
ಸರ್ 27th ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದು.
ಇಲ್ಲ ಇರೋದೇ 4 ಇದೆ ಅದರಲ್ಲಿ. ಮೇಡಮ್ 70 ಯು ಆರ್ ಪ್ರೆಸೆಂಟ್. ಇಂಟ್ರಿ ಮಾಡಲ್ ಎಲ್ಲಿದೆ ಎಲ್ಲ ಕಡೆ.
No 74 minus.
ನೆಕ್ಸ್ಟ್ ಫೆಬ್ರವರಿ ಕೊಡ್ತಾರೆ. ಇಲ್ಲ ಮತ್ತೆ ಹಿಂಗಾಗುತ್ತೆ. ಯಾವ್ದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್? 31ನೇ ತಾರೀಕು ಕೊಟ್ಟಿದ್ದೀನಿ. 25 ಬೆಳಿಗ್ಗೆನೆ ಮುಗಿದಿದೆ ಸರ್. ಇಂಟ್ರಿ ಮಾಡಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಟೆಪ್ಸ್ ಏನಾದ್ರು ತಗೋಬೇಕಂತ ಹೇಳಿದ್ರು ಅಷ್ಟರಲ್ಲಿ 28 ಒಳಗಡೆ. 68 31st ಆಗಿದೆ. ಇಲ್ಲ ಅದು 2 4ನೇ ತಾರೀಕು ಕೊಟ್ಬಿಡ್ತೀನಿ ನನಗೆ. ಸರ್ 4th ಕೊಟ್ಟಿರ್ತೀನಿ. ಮತ್ತೆ ಹಿಂಗೆ ಆಗುತ್ತೆ ನೋಡಿ. ಅದಕ್ಕೆ ಹೇಳ್ತೀವಿ ನಾವು 4th ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಬೆಂಗಳೂರ್ದು ಯಾವುದೂ ಇಲ್ಲ, ಜಾಮ್ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಈ ವೀಕಲ್ಲಿ ಅದೇ ಇದೆ ಕಡೆ. ಅದಕ್ಕೆ ನಾನು ಫೆಬ್ರವರಿ ಕೊಟ್ಟಿರೋದು. ಇಷ್ಟು ಅದಕ್ಕೆ ಹಾಕಿದ್ದು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 4th ಹಾಕಿದೆ ಸರ್. ಲಿಸ್ಟು ಬೆಳಗ್ಗೆ ಮುಗಿದಿದೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಇಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. 5th ಗೆ ಲಿಸ್ಟ್ ಮಾಡೋಕೆ ಹೇಳಿದ್ದಾರೆ. ಎಂಟ್ರಿ ಮಾಡಲ್ ಎಲ್ಲದರಲ್ಲೂ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
7 ಲಿಸ್ಟ್ 7.
ಸರ್ 30ನೇ ತಾರೀಕಿಗೆ ಅದಕ್ಕೆ
31
ಲಿಸ್ಟ್ 3 ನಾ
73 ಫಸ್ಟ್ ಲಿಸ್ಟ್
28/1
ಸೀರಿಯಲ್ ನಂಬರ್
28/1 ಮಂಗಳವಾರ
73 ಫಸ್ಟ್ ಲಿಸ್ಟ್
10/2
ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಸೀರಿಯಲ್ ನಂಬರ್ 70
ಹಾ
ಡೇಟ್ ಇದು
10/2 ಕೊಟ್ಟೆ
ಅಷ್ಟೇ. ಇದು ಯಾರು ಸರ್ ಇದು ಯಾರು
ಡೇಟ್ ಬಿಡಿ.
ಅಲ್ಲ ನಮ್ದು